Committee of Water Resources and Environment Subcommittee of Transportation and Infrastructure will come to order. Today, having a hearing on the impacts of a proposed rule by the U.S. EPA and the Army Corps of Engineers of waters of the United States. A couple housekeeping issues here first. We've received numerous requests for written testimony to be submitted to the record. I ask for unanimous consent that all written testimony be included in the hearing record, be kept open for 30 days after this hearing in order to accept these and other submissions of written testimony. Any objection? Hearing none, so ordered. Take care of there. Welcome to our first panel. After we do our couple opening statements, we have the U.S. EPA Deputy Administrator and Secretary of Army Corps of Engineers, Secretary Darcy. Then we'll have a panel 2 after the first panel of 6 individuals representing various government entities and associations and the challenges that they see with the proposed rule and the impacts. I'll yield myself time here to provide an opening statement. First of all, again, I'd like to welcome everybody to the hearing today. The potential impacts of the proposed changes to the Clean Water Act jurisdiction rule, which aims to redefine the term waters of the United States. On April 21st of this year, the EPA and the Army Corps of Engineers published a proposed rule in the Federal Register that, according to the agencies, would clarify the scope of the federal jurisdiction under the Clean Water Act. After reviewing the proposed rule, I have serious concerns about the rule and the process the agencies are following to develop it. Since 1972, the Clean Water Act has been instrumental in dramatically improving the quality of our nation's waters. Fundamentally to that progress has been the federal-state partnership, which recognizes that not all waters need to be subject to federal jurisdiction, and that the states should have the primary responsibility of regulating waters within their individual boundaries. However, I am concerned that this rule will undermine the federal-state partnership and erode state authority by granting sweeping new federal jurisdiction to waters never intended for regulation under the Clean Water Act, including ditches, man-made ponds, floodplains, riparian areas, and seasonally wet areas. In promoting this rule, the agencies are implying to the public that massive amounts of wetlands and stream miles are not being protected by the states, and that this rule, which will essentially federalize all waters, is needed to save them. However, nothing is further from the truth. States care about and protect our waters. I also am concerned how the proposed rule misconstrues and manipulates the legal standards announced under Swank and Rapano's Supreme Court cases, effectively turning those cases that place limits on Clean Water Act jurisdiction into a federal justification for the agencies to expand their assertion of federal authority over all waters nationally. The agencies have had an opportunity to develop clear and reasonable bright-line rules of what is jurisdictional versus not, but they instead chose to write many of the provisions in the proposed rule vaguely in order to give federal regulators substantial discretion to claim federal jurisdiction over most any water or wet area. This is dangerous because this vagueness will leave to the regulated community without any clarity and certainty as to their regulatory status and will leave them exposed to citizens' lawsuits. In addition, since many of these jurisdictional decisions will be made on a case-by-case basis, as they have stated, and this will give the federal regulators free rein to find jurisdiction. This rule, in essence, will establish a presumption that all waters are jurisdictional and will shift to property owners and others in the regulated community the burden of proving otherwise. This rule set a very high bar for the regulated community to overcome. Nevertheless, the agencies continue to claim that no new waters will be covered by the rulemaking. The agencies cannot, through guidance or a rule, change the scope and meaning of the Clean Water Act, as they are trying to do here. I am also troubled that the sequence and timing of the actions of the agencies that have been taken to develop this rule are undermining the credibility of the rule and the process to develop it. First, instead of initiating a rulemaking process by soliciting input from and developing consensus with the general public, scientific communities, the federal and state resources agencies on how to identify the appropriate scope of jurisdiction, the agencies rushed ahead on their own and developed the draft guidance that would be agencies' own admission increases significantly the scope of the Clean Water Act's jurisdiction over more waters and more provisions of the Act. Then, after facing substantial bipartisan opposition to the expansive new guidance, the agency proceeded ahead again on their own with a rulemaking that's simply based on the expansive guidance. And to hide the inadequacies of the rulemaking process that the agencies have embarked on, EPA decided to develop a so-called scientific study that is supposed to provide a basis for determining the reach of federal jurisdiction under the Clean Water Act. It is disturbing that the EPA intentionally precluded from a study a review and discussion of the scientific concepts that are highly relevant to determining which waters should be subject to the Clean Water Act coverage. The interconnectedness of the science and the policy issue here warrants rigorous scientific peer review prior to the ruling's crafting. However, instead of waiting until the science study was completed, the agencies wrote the rule long before the study's report has peer-reviewed and finalized. The agency also took steps to hide the regulatory impacts of the rulemaking by preparing a flawed economic analysis that did not comprehensively assess all the costs and benefits. This is very troubling because this rule, if not carefully crafted, will have sweeping economic and regulatory implications for the entire nation by adversely impacting nearly all sectors of the economy, threatening jobs, increasing compliance costs, restricting the rights of landowners, inviting costly litigation, and undermining the ability of states and local governments to make decisions about their lands and waters. Regulations of the nation's waters can and must be done in a manner that responsibly protects the environment without unnecessary and costly expansion of the federal government. Finally, I am pleased to hear that agencies have just announced a 91-day extension of the public comment period of the proposed rule. However, the agencies should extend the comment period on the proposed rule until after the EPA Science Advisory Board has completed its review of the science study and the study's report is thoroughly vetted to ensure that any final rule is based on the final peer-reviewed report. I look forward to the testimony from our witnesses today, and now I would recognize Chairman Schuster of the Transportation Infrastructure Committee for any statement or comments you may have.
Thank you, Mr. Chairman. The President's published proposed rule, which, of course, Mr. Gibbs did a great job of going through it, it will dramatically extend the reach of the federal government when it comes to regulating ponds, ditches, and wet areas. And I don't believe anybody's going to dispute that. I mean, we may attempt to hear that today, but that's what's going to happen. But this is another example of this administration seeks to use executive action, brute force, to ignore, bypassing Congress, ignoring Supreme Court rulings of the past, unilaterally broadening the scope of the Clean Water Act and the federal government's reach into everyday lives will adversely affect the nation's economy, threaten jobs, invite costly litigation, and restrict the rights of landowners, states, and local governments to make decisions about their own lands. This massive federal jurisdictional grab was the subject of failed legislation in the 110th and 111th Congress, and I know my colleagues over there were in the majority at the time, and I hope we can join together to fight back on this because, once again, this is going to be Congress ceding power to the executive branch. And if we do that, if we allow this to go forward, we will never get that back. And I don't care if it's a Republican president or a Democrat president. We give it up, and they will never give it back to us. So this is a fight we need to have, and we need to win. In the 110th and 111th Congress, it was strong bipartisan support to prevent those bills from moving forward. And as I said, the administration is now doing an end around Congress to try to see that, to gain that federal power expansion through this rulemaking. The rule supposedly aims at clarifying water bodies that are subject to federal jurisdiction under the Water Act. But as I said, I'm concerned that there are serious flaws in this rule, and the executive branch will take power away from the Congress. Twice, the Supreme Court has told the agencies there are limits to the federal jurisdiction under the Clean Water Act, and they had gone too far in asserting their authority. Now the administration appears to be cherry-picking those Supreme Court rulings, taking out language and attempt to gain this expanded authority, rather than heeding the directive of the court. It's the responsibility of Congress, not the administration, to define the scope of the jurisdiction under the Clean Water Act. This rule will have sweeping economic and regulatory implications for the entire nation, and I believe that the agencies would be better off correcting the deficiencies in this rulemaking and develop a rule that is credible, reasonable, and consistent with the law. Regulation of the nation's waters must be done in a manner that protects the environment without unnecessary and costly expansion of the federal government. We we can continue to protect our waters without unreasonable and burdensome regulations on our business, farmers, and families. So again, I have tremendous concern. This is something that I know that those of us on our side of the committee are going to fight to make sure this doesn't move forward, and that we as Congress, and I would again encourage my Democratic colleagues to look at this as this is a fight between the executive branch and the legislative branch. This is our constitutional duty, and they're going to take it away from us. And I said to you, if this were a Republican administration, I'd be saying the same thing and fighting it just as hard. So I encourage you all to keep an open mind as we go through this, and let's fight to keep Congress relevant in this process. I yield back.
At this time, I recognize the ranking member of the full Transportation Infrastructure Committee, Mr. Rahal.
Thank you very much, Mr. Gibbs. I appreciate you as chairman holding this hearing, and I appreciate very much our witnesses being with us today on both panels. This is an excellent opportunity to examine and question the regulations that are pouring out of the Environmental Protection Agency. We are told that this latest regulation defining waters of the United States is an attempt to address the muddled mess of what waters are subject to the permitting processes of the Clean Water Act. Certainly, the most recent Supreme Court decisions on the matter have only left the question increasingly murky, opening a legal void that is begging to be addressed. Unfortunately, from all that I have seen and heard to date, this latest proposed rule has only further muddied the waters. I've heard many times from proponents of this rule that the intention in crafting it was to provide certainty so that businesses and individuals, before setting off on some undertaking, would know whether or not they needed to go through the lengthy and expensive permitting process. On that score, I have to give credit where credit is due. This proposal certainly does provide certainty. The certainty that if you want to undertake an activity whatsoever that may involve so much as a puddle, you must seek a permit. So I confess, I am terribly frustrated. I represent a state that has been brutally beaten up by the barrage of regulations gushing out of the EPA. We feel we are under siege from an agency so power-hungry that it is gobbling up jurisdiction and taking power away from our states, away from other federal agencies, and ultimately away from the people. And any serious person looking at this agency would have to question if it has bitten off more than it can chew already. The EPA likes to cultivate the impression that science and pragmatism govern the day and that it is not swayed by ideology. But I see it differently. I see an agency that is so hard over against coal that it will gloss over the science in doing so, and if doing so, helps to stop the construction of coal-fired power plants. I see an agency that is so blinded by an anti-coal philosophy that it will stonewall efforts to provide coal-field residents with modern sewer systems and safer water. It is an agency that is willing to block construction of a major national highway at huge savings to the American taxpayers if it would involve the mining of a little coal. This committee is right to view this new proposal with skepticism. We must look candidly and matter-of-factly at the cost of this latest EPA proposal on the waters of the United States and its effects on our jobs, on our economy, and on the course of our nation. So I thank the chairman for allowing me these opening comments, and thank him again for having this hearing today.
Thank you. At this time, I recognize my ranking member, Mr. Bishop, for any comments he may have.
Thank you very much, Mr. Chairman, and thank you for holding today's hearing. Let me take a moment to frame out the context of today's hearing and try to highlight some of the factors that brought us to where we are today. The starting point of all of this was Congress's passage of the Clean Water Act in 1972, which was approved by a veto override by a 10-to-1 margin over President Nixon's veto. In that law, the Congress broadly defined the scope of the Act as the navigable waters, meaning the waters of the United States and the territorial seas, and directed the agencies before us today to fill in the details. For almost 30 years, the agency's regulatory definition of those terms were the law of the land, And since enactment of the Clean Water Act, we have seen dramatic improvement in the number of water bodies that are safe for fishing and swimming, up from 1/3 of the nation's waters in 1972 to approximately 2/3 of the nation's waters today. I hope we can all agree that's a good thing. And I hope we can also all agree that that improvement would not have happened were it not for the Clean Water Act. Then, in 2001, a stakeholder challenge on the Act's application with respect to an Illinois landfill resulted in the Supreme Court questioning the application of these definitions. Later, in 2006, the Supreme Court again questioned the application of these rules to 2 wetlands in the state of Michigan. In the latter case, the Rapanos case, Chief Justice Roberts wrote that the Corps and the EPA needed to do a better job in defining the scope of the Clean Water Act. So if this is in fact a conflict between branches of government, the conflict is between the judicial branch and the executive branch. This is something that has been attempted by the last 2 administrations, the administration of President George W. Bush and the current administration. In 2003, the Bush administration initiated a public rulemaking to define the term waters of the United States, consistent with the rulings of the Supreme Court, as well as took public comment on whether other regulatory definitions on the scope of the Clean Water Act jurisdiction also needed clarification. In response, several outside stakeholders, including some of the groups represented here this morning, recommended that the agency use the rulemaking process as a means of providing increased clarity to the, quote, hodgepodge of ad hoc and inconsistent jurisdictional theories, close quote, as well as to define other terms in the regulations, including such terms as tributary and adjacent. The 2003 rulemaking attempt by the agencies never reached its conclusion. Following in the footsteps of the Rapanos decision, the federal agencies released 2 interpretive guidance documents, one in 2007 and a second in 2008, the latter of which remains in force today. Now let's fast forward to 2014. The list of stakeholders publicly recommending that agencies carry out a rulemaking has expanded and now includes groups ranging from the National Wildlife Federation to the Waters Advocacy Coalition. In response, earlier this year, the administration initiated its own rulemaking to do just that, to clarify the scope of the Clean Water Act consistent with the parameters laid down by the Supreme Court over the years. Now, I'm not naive enough to expect that the various groups following this proposed rule would agree on how to clarify the scope of the Clean Water Act or where the bright lines of jurisdiction should lie. However, I do believe it is reasonable for the agencies to be allowed to continue this open process in providing the clarity that these stakeholders have demanded over the years. If the stakeholders have concerns or recommendations for changes to the proposed rule, that is what the public comment period was created for. And I strongly encourage all interested parties to utilize this open process to make their views known. However, I do not support throwing out the entire rulemaking process simply because there is disagreement with the initial draft. Going back to the legal state of play, in the past 30 years, the Supreme Court has issued 3 rulings that directly address the scope of the Clean Water Act: the Bayview Homes case, the Swank case, and the Rapanos case. Each of these decisions outlined a piece of the puzzle for defining the scope of the Clean Water Act. In the Bayview Homes case, the justice unanimously agreed that certain wetlands fell within the protections of the Clean Water Act. In the Swank decision, the 5-4 majority of the court ruled that the presence of migratory birds on a water of the United States could not be the sole basis for determining jurisdiction. Finally, in Rapanos, the court issued a 4-1-4 decision where 4 justices, led by Justice Scalia, outlined a relatively permanent waters test for determining jurisdiction, while Justice Kennedy established a complementary test, the so-called significant nexus test, for determining jurisdiction, and the remaining 4 justices agreed with the agency's current authorities. These 3 decisions outline the 4 corners of the Supreme Court's interpretation of the scope of the Clean Water Act. So in my view, the question becomes, how does the April 2014 proposed rule compare with tests on the Clean Water Act scope as outlined by the Supreme Court? This will be the area of questioning that I will focus in on today as this hearing progresses. If the stakeholders today suggest a different approach, I welcome their input as well. Mr. Chairman, I hope that all involved with today's hearing will use this hearing as a learning experience about what this rulemaking does and, as important, what it does not do. I welcome the witnesses here this morning. I look forward to your testimony. I yield back.
And if any other members have opening statements, they can submit their written testimony for the record. This time we'll recognize our panel one. We have the Honorable Robert Pershesky. He's the Deputy Administrator of the United States Environmental Protection Agency, and we also have the Honorable Joanne Darcy, who's the Assistant Secretary of Army Civil Works. Mr. Pershesky, I will recognize you first. The floor is yours. Welcome.
Thank you, Mr. Chairman and members, ranking member. Thank you so much for inviting us today.
Can you pull your mic up a little bit closer, maybe?
Apologize. I think we all agree, and I've heard this already, that we want clean and safe waters for ourselves, our economy, our environment, our children, our future. I also want to express my appreciation to my colleague and friend, Assistant Secretary of the Army, Joanne Darcy, for her leadership and commitment to protecting the nation's waters. We are undertaking a process to clarify the geographic scope of the Clean Water Act and to improve a regulation that has been in place for nearly 30 years. The proposed rule will help provide families, manufacturers, farmers, sportsmen, energy producers, and the American people with the clean water they depend on. A written testimony that I have submitted will provide more details about the proposed rule, including the agency's goal to respond to the requests from stakeholders across the country to make a process of identifying waters protected under the Clean Water Act easier to understand, more predictable, and more consistent with the law and peer-reviewed science. We believe this rulemaking will minimize delays, costs, and improve predictability, clarity, consistency for everyone and who may or may not need a Clean Water Act permit. I will focus my opening remarks this morning on some of the misinformation that exists regarding the potential effects of this rule. And I'm concerned that incorrect information may have the effect of distracting the attention from the legal policy and scientific underpinnings of the proposed rule. The agencies are meeting with Americans across the country, including farmers, energy companies, small business, state and local governments, sportsmen, developers, and many others, to solicit their comments, because remember, this is a proposal, and to answer their questions about it. We are hearing from the public directly and personally about how to improve the rule and how to make it most fair, flexible, and effective for everyone. In addition to providing valuable insights to our discussions, are also revealing an unfortunate pattern of misinformation. For example, I've heard in my discussions with stakeholders that this regulation will require farmers to get permits for their cows to cross a stream, that this regulation will make dry washes that carry water only once in 1,000 years protected under the Clean Water Act, that this rule will make entire floodplains subject to the Clean Water Act jurisdiction. And I can tell the committee that categorically none of these are correct statements. In contrast, here are some of the examples about what the proposed rule does and does not do. In adherence with the Supreme Court, it would reduce the scope of waters protected under the Clean Water Act compared to the existing regulations on the book. It would not assert jurisdiction over any type of waters not previously protected over the past 40 years. The rule does not apply to lands, whole floodplains, backyards, wet spots, or puddles. It will increase transparency, consistency, and predictability in making jurisdictional determinations and reduce existing costs, confusion, and delays. It represents the best peer-reviewed science about functions and values of the nation's waters. The agencies will not finalize this rule until the Science Advisory Board completes its review, which you mentioned, Mr. Chairman. It would reduce Clean Water Act jurisdiction over ditches compared to the previous 2008 guidance. The rule will maintain all existing Clean Water Act exemptions and exclusions. In addition, the agency has also identified agricultural conservation practices conducted in waters that do not require a 404 permit. We want to encourage conservation work on agricultural land. We have published a proposed rule, not a final rule. We are currently taking public comment, and we've extended the comment period, as you've already heard. We expect a tremendous amount of public response from a broad range of interests, and we are actively working to meet with a wide range of stakeholders. This outreach has already been tremendously helpful to us in understanding the concerns and discussing effective solutions. We're going to continue to work hard and listen more effectively and learn more and better understand. Let me just conclude by emphasizing my strong belief that what's good for the environment and clean water is also good for farmers, ranchers, foresters, manufacturers, home builders, small businesses, communities, energy producers, and all Americans. We look forward to working with all stakeholders to reflect this important goal in the final rule and defining the geographic role of the Clean Water Act. And I thank you, and I look forward to your questions.
Secretary Darcy, welcome. The floor is yours.
Thank you. Good morning, Chairman Gibbs, Ranking Member Bishop, and other members of the committee. Thank you for this opportunity today to discuss the proposed rule clarifying the definition of waters of the United States under the Clean Water Act. Once implemented, this rule will enable the Army Corps of Engineers to more effectively and efficiently protect our nation's aquatic resources while enabling appropriate development proposals to move forward. Clean Water Act jurisdiction applies to navigable waters, defined in the statute as waters of the United States, including the territorial seas. Our 1986 regulations define waters of the United States as traditional navigable waters, interstate waters, all other waters that could affect interstate or foreign commerce, impoundments of waters in the United States, tributaries, the territorial seas, and adjacent wetlands. The U.S. Supreme Court has addressed the scope of waters regulated under the Clean Water Act in 3 occasions, specifically the Riverside Bayview Homes case of 1985, the Swank decision in 2001, and the Rapanos decision in 2006. The Court's decisions significantly altered the regulatory landscape. And although the Corps and the Environmental Protection Agency have done a fine job adjusting their regulatory activities in response, a critical need exists for this rulemaking. We received many comments from Congress, from organizations, from stakeholders, from the public, urging the agencies to pursue notice and comment rulemaking, including Chief Justice Roberts himself in the Rapanos decision strongly recommended that the agencies initiate a rulemaking. We've been working for several years now to develop a science-based rule that will provide the clarity needed, the transparency, as well as the efficiency. Under the proposed rule, the process of identifying waters of the United States will become less complicated and more efficient as to which waters are and which waters are not jurisdictional. Our proposal does not assert jurisdiction over any new category of waters. However, we do expect that there will be a small increase in jurisdiction over the existing 2008 guidance, but the extent of jurisdiction is less inclusive than the 1986 regulations. Our decision to propose to regulate by rule all tributaries and adjacent waters and wetlands is scientifically based and is consistent with our understanding that these waters, alone or in combination with similarly situated waters in the watershed, have a significant nexus to jurisdictional waters. Other waters may be determined jurisdictional only upon a case-specific determination that a significant nexus exists between the jurisdictional water. This is consistent with our current practice. The proposed rule will also exclude certain waters and erosional features. Waste treatment systems and prior converted croplands remain excluded. We anticipate receiving meaningful comments on the proposed rule, and as you know, the comment period has just been extended till October of 20th of this year. Mr. Chairman and members of the committee, I'm happy to answer your questions and look forward to this hearing. Thank you.
Okay. At this time, Mr. Chairman of the committee, Bill Schuster, do you have? Okay. He yields to former Chairman, Mr. Young from Alaska.
Thank you, Mr. Chairman. I want to thank the witnesses. I have a personal feeling about the EPA. I want you to know what you've done in Alaska, to me, is a disgrace. Without any input from the state of Alaska, any cooperation with the state of Alaska, any understanding of the effect upon individuals in the state of Alaska, preempting a state-owned property without consulting, totally arrogance on part of another agency. The second thing, Mr. Giuseppe, is the influence you have, Ms. Dacey, on your agency, where we just now have a core request of a new way to allow family mining to take place. And I have information, it was submitted by the Corps for permitting because of the EPA. That's not right. You are a separate agency. You should have the ability to make decisions based upon other than I call a policy of EPA that doesn't understand that there is economics, there's a human life that involves, and that's the last of my statement. But I'd like to just ask the question, to the EPA. And in this bill, have you indicated the costs were underestimated? Are you doing anything about that? Are you looking at the cost of this legislation upon the economy and upon individual states?
Thank you for the question. Yeah, we have a draft economic analysis that accompanies the proposal. Our draft economic analysis does identify the costs, and it does identify the benefits that we anticipate.
But is it true it was you underestimated the cost in this proposal?
We do not believe we've underestimated the cost.
So you're not doing anything about it?
Well, it's a proposal, so we're taking comment on the economic analysis, and if we do get comment that demonstrates any modification or improvement that we can make on it, we will obviously take that into account.
Did you consult with any of the states involved or any of the states in the United States on this proposal?
We've had discussions, ongoing discussions with the states, and we continue to have.
Have you found one state that supported this proposal?
I don't have a polling of the states.
So you really didn't consult, because I don't believe there's one of the 50 states that support this proposal.
I couldn't say that one way or the other.
Well, you're the agency. You should know that if you're consulting. There should be somebody, one state, saying this is a grand idea. And if you don't know, that means you didn't consult with them.
We did consult with them.
Well, no, because you didn't do it well enough. You didn't write it so the states could accept it. You've got 50 states that say they don't like this program. 50 states, sir, and you represent 50 states supposedly as an agency.
I don't believe 50 states have said that.
Oh, well, do you believe they said in one state? Give me one state.
The way we...
One state.
I'm sure they'll...
You have not one state.
I don't have one
You
state.
have not one state that supports this proposal.
All right, you won't let me answer, so go ahead.
No, I know. I'm asking you a question. You can't do it.
All right, you have to stop
you
talking
can't
so
do
I
it.
can answer.
You can't do it. Now, that's what bothers me. Now, if I have a private piece of property under the Constitution is mine,
Yes, correct.
and I have water on it, can you, under this rule, go in and tell me I cannot make a difference in the water that's on my property? I cannot drain my pond under this rule?
If those waters are jurisdictional under the Clean Water Act, you would have to get a permit to do it.
The question is very
The permit-
simple. I have a pond of water. It is on my private land. It is my water. Is that not true? It's my water?
It is on your land.
Is it my water?
That varies from state to state on water rights.
I ask you as federally. The state has not proposed this. It is my water. It's on my property, and I want to drain it. Can I do that without your permission?
The United States Congress has enacted a law that requires a permit to do work in waters that are jurisdictional under the Clean Water Act. So if it is, and I have no idea whether it is or not because I don't know which water you're talking about,
It's my
it
property.
would require a
It's very simple.
permit.
This is my ranch.
It would require a permit if it is jurisdictional. If it isn't jurisdictional, you won't need a permit.
Mr. Chairman, if I say so in the committee, this is an example. Under the Constitution, you have a right on your property to protect your property. If I want to drain it because I call, what do you call these fish that walk across the water on the land and get in the other area, and I want to kill those fish, but I can do it by draining it, and now I have to get a permit from you, and your agency says, no, you can't do it because we have not given you a permit. You're taking from my right to run my land. That's unconstitutional. And you, both of you, have sworn to uphold the Constitution.
That is correct.
And you're not doing it if I can't run my land and my water. Mr. Chairman, that's an example of the overstepping of this government. I've watched this for 81 years. We have a government today, Mr. Chairman, that's running individuals, taking away the right of individuals' rights. And I say to the agency, the people are going to stand up on these things and say, no more. That's enough.
All right.
Not going against the Constitution, sir. You're not going against the Constitution. And my time is done. Let the chairman do it. Let everybody else start asking these questions.
Thank you. Mr. Rahal.
Thank you, Mr. Chairman. I'll try to be a little tamer. Mr. Administrator, as we all know, the coal industry, coal mining jobs, crucial, vital to my home state. It's our livelihood. Coal literally keeps the lights on. And when we have downturns, for a variety of factors or a variety of reasons contribute to those downturns in the industry, as we're in now, there are layoffs of law enforcement personnel by county commissioners who cannot find the funding to keep officers on the street or even keep the lights on in their courthouses or keep staff employed. So there's a lot of families watching these proposals in my district, as they did the recent proposals announced last week, and they're worried about their jobs. They're receiving warn notices as we speak. Again, there's a variety of factors for this downturn. I recognize that. Everybody recognizes that. But in these downturns in the past, we've always felt the government's trying to help us get out of these downturns in the coal industry. That's not the feeling now. Matter of fact, just the opposite. Our government's trying to keep us in a downturn and trying to finish us off during this current down cycle. So, you know, as I say, everybody's worried about everything that comes out of the EPA in the district I'm honored to represent. Several years ago, the agencies went through an extended exercise to align various definitions of fill material. That has a lot in the industry concerned. My question to you would be, is the EPA planning now to revisit that and redefine what is fill material?
Congressman, we have absolutely no plans to revisit that.
Okay. Let me ask you another question on the issue of properly permitted ditches on mine sites that are in place to address stormwater runoff. Is the rule expected to capture these on-site drainage systems?
The way, looking specifically, for instance, at a permitted coal mining site, we would expect that the waste treatment exclusion in the rule that we are continuing in the same way it's always been there will continue, which covers many of those. Any stormwater ditches or ponds that were constructed to convey or deal with stormwater control on mining sites would not be covered, and we are not changing the water treatment or the waste treatment system exclusion rule, the proposal of the rule. So with those clarifying points, which are reinforcing the fact that the answer is no, they would not have jurisdiction over those treatment facilities that are on a permitted mine site.
So the industry can continue to rely upon your long-standing agency interpretations regarding these uses.
Yeah.
Madam Secretary?
Yes, those exclusions will stay in place under this proposed rule.
Okay. Thank you. I yield back, Mr. Chairman.
I've got some questions. First of all, you're absolutely right. We need to make sure we bring certainty to our businesses and our farmers and everybody out there. But there's so much vagueness. And when I hear your testimony, and I've actually read the testimony of the next panel, I hope you are able to stay around to hear the next panel, since you're the regulators, and see what their concerns are. So I really would appreciate if you were able to stay around and hear their testimony, because they're really concerned about that too, and they've got a little different take on that. First of all, some of the things Mr. Pisewski said, I hope that you can put that in writing, because sometimes just saying things, we like to have it down in writing and for the official record. But Ms. Darcy, we talked about vagueness. In your testimony, it says, the agencies proposed that waters outside of the riparian and floodplain areas would be jurisdictional only if they are confined to surface or shallow subsurface connection to the traditional navigable waters, and so on. Would you please explain to me what you mean by the connectivity, or the surface or shallow subsurface connection? Because you say you're not expanding the scope of your jurisdiction, but I don't know what that means.
Congressman, what it means is that if there is a connection between that and the floodplain, and if the floodplain is a navigable water, then that significant nexus determination would need to be made.
Any connection or a significant connection? I don't need to de minimis anything, but...
No, a significant connection, and we define significant nexus in the rule as to how significant that would be. It has to be able to impact the flow of the navigable water.
Would you explain to me how you define significant?
Pardon me?
Would you explain to me how you define significant?
I'll read you the definition if that'll help. I have it here. I know I do. I need my glasses. A significant nexus means that a water, including a wetland, either alone or in combination with other similarly situated waters in the region, in that watershed, significantly affects the chemical, physical, or biological integrity of a water identified as a jurisdictional water.
So, for example, out west, when I've been out west, I've seen areas where they might get water flowing through an area during once in a year rain event. It's dry beds. Would that be significant?
That, again, would be an individual case-by-case determination, depending on the circumstances in that area. For example, some of those kinds of waters, if they are determined to be a tributary, which is defined as a water body that has a bed, a bank, an ordinary high water mark.
So you could. So let's say I had on my farm here last month. I had a washout, and I went out there and I fixed it. I had it was probably 200 feet long. It washed out. It was close to 2 feet deep, 2 feet wide, and I had to fill that in. And I planted grass and tried to do the right thing to fix that. Now, if you came out, the Corps came out, would they say that was a bed, water bed, or would I be able to fix that without getting a permit?
Congressman, what you have described would be an erosional feature that would not be subject to a jurisdictional determination.
Okay. Just a question. When I read through the testimony of the next panel, there was a lot of concern that the states haven't been consolidated, local governments haven't been consolidated, so I just want to make you aware of that, Mr. Przybylski, that there's concern about that. Also, there's a huge concern of local governments, road ditches, because you talked about, I think when you use significant, the bed. So I think you could define that as a ditch now on the new definition as a tributary. Does that mean when they're doing a dredge or cleaning out the ditch that they're going to have to get a permit? I think.
Congressman, for the first time, we are excluding in this rule ditches, and if you'd like, I can give you the two examples of what kinds of ditches. If the ditch.
What's that? Well, I guess that's there's some controversy if you really are or not, and I think the trust factor here. We've seen some of the things the EPA has done in the past with the revocation of permits and veto of permits and preemption of permits. That I think there's a high level of distrust out there, and there's a really concern about how we move forward on that area. Okay, I'm just about out of time. I think I'll turn it over to Mr. Bishop.
Thank you, Mr. Chairman. Secretary Darcy, first off, thank you for reading the definition of significant nexus. Am I correct in understanding that the language in the significant nexus definition as included in the proposed rule is lifted almost verbatim from Justice Kennedy's ruling in the Rapanos case?
I believe, I believe that to be the case. And also, I'd just like to reiterate that the definitions are also part of what's being proposed in this rule as being open for public comment.
But you are staying wholly within the confines of Justice Kennedy's definition of significant nexus in this proposed rule. Is that correct?
That's correct.
And is it also correct that Justice Scalia, in his definition of relatively permanent connection to traditionally navigable waters, suggested a hydrological connection in his ruling? And is it not the case that your proposed definition adheres to Justice Scalia's definition? Am I right about that?
That's correct.
Thank you. Now, let me ask you this. There are these two rules. Or two tests, the relatively significant nexus test and the traditional, relatively permanent connection test. Is there any way in which any aspect of your proposed rule extends jurisdiction beyond the four corners of those two definitions?
No.
Mr. Percisepi, do you agree with that?
I do, and in fact, I would just augment slightly that in addition to the definition that the colloquy just discussed here, or the discussion on the words in the Supreme Court justice, we actually are using this rulemaking to, by rule, exclude certain things So even with that test, some, notwithstanding if they would pass that test or not, they are excluded. Things like, as to go back to the chair's question, ditches that are excavated wholly in uplands, that drain only in uplands, and that have less than perennial flow, which is virtually most of the highway drainage ditches in the country. You know, they're not draining a wetland, they're not draining a stream, they're just draining dry land when it rains. Those are excluded in the definition of the rule. So I just wanted to add that to Assistant Secretary
But
Darcy.
just to be clear, this has been described as a power grab. It's been described in other ways, somewhat even more pejorative than that. Your definitions are definitions that hew precisely to the definitions suggested by the two Supreme Court rulings.
That's correct.
Thank you. All right, let me move to another area. The operative guidance that we have right now is the 2008 guidance. The 2008 guidance asserts jurisdiction over dry land ditches that flow less than year-round. Yet the proposed limits jurisdiction, your proposal, limits jurisdiction by requiring water year-round. Am I correct, therefore, in determining that jurisdiction over fewer ditches would be asserted under your ruling than is currently the case today?
That's correct.
Okay. So it limits rather than expands the scope of the Clean Water Act in that particular case. Am I right about that?
That's correct.
Okay. All right, let me just ask one more question. Are there any examples where the proposed rule expands the definition of jurisdictional waters that is currently the case under the 2008 guidance?
No.
Mr. Perciasepi, do you agree with that?
I do. There's no expansion.
And does it, in fact, limit some of the jurisdiction?
It does. In fact, some of those limitations, as I mentioned, have to be done through rulemaking.
Okay. So those who are proposing that we prohibit the use of federal funds to allow this rulemaking to go forward or to enforce that rule, this might be falling under the heading of be careful what you hope for, because the 2008 guidance is more restrictive than what this rule is proposing. Is that a correct interpretation?
In some instances, that's correct.
Okay. Mr. Perciasepi, do you agree with that?
I do.
Okay. Thank you very much. I'll yield back.
Mr. Schuster.
Thank you, Mr. Chairman. Some words have been used here. Flexibility. Flexibility is a great thing when you're able to do, both sides of both parties get to use flexibility. My concern is that when you talk about flexibility, the stakeholders seem to never get the flexibility to come under a rule and be able to mitigate the problem themselves in a way that it will work. What typically happens that I see is when you talk about flexibility, it allows the EPA and the Corps the flexibility in different districts and different regional offices across the country to interpret these things differently. And we see that in Pennsylvania, in the Marcellus gas play, where the Corps office in Baltimore is treating Pennsylvania and wherever else the other places it has a jurisdiction differently than what happens in Arkansas and other places in this country, because the local office is interpreting these rules and regulations in a different way. For instance, also the word significant. Significant, what it means to me and what it means to you is different. I'm not a scientist. I'm not a geologist. You don't have specifics in there as to really what significant is. It requires a measurement of some sort, then I can understand it, or a measurement that a farmer or a developer can understand. So you've got all these nice terms in here, but when you look at how you've made these definitions, tributary, adjacent, floodplain, neighboring waters, they're very vague. To my understanding, and to when we talk to the stakeholders today and have been talking to them, that they're very vague to them. Can you tell us now what waters would definitely no longer be regulated by the federal government under this proposed rule?
We have a series of exclusions that are defined here, and if you'd like, I can read those to you. It's under Section B1 of the definition of the rule. It's waters that are not going to be considered are wastewater treatments, prior converted cropland, ditches that are excavated wholly in uplands, ditches that do not contribute flow either directly or through other waters to a water, and artificially irrigated areas that would revert to uplands, artificial lakes. This whole list, do you want me to continue?
But so if the water somehow seeps into a body of water that's flowing, because of a flood or something occurring, some extreme weather event occurs, will that enable the regulators to change the definition of that ditch or that pond to fall under the federal jurisdiction?
Congressman, if the water body contributes to the flow of a tributary, then that would be considered a jurisdictional.
So we get a 100-year storm, and floods the typically irrigated field and a diversion ditch on a farm, and which never flowed into to a river that's close by. If that event occurred, then would that come under federal regulation?
Congressman, it sounds as though you're describing a flood event and the runoff from that flood event, and that kind of runoff would not be considered a jurisdictional water of the United States.
When you talk about waste treatment, yes, sir.
Just to add in, because I think this gets at some of the potential need for continued dialogue. We're using the term floodplain to try to get at the issue of adjacency, which has been in a number of the Supreme Court cases. But just because it's a floodplain doesn't mean it's jurisdictional. It still would have to be a water in the floodplain, standing water or a wetland with the hydric soils and the vegetation, or an actual running stream through a floodplain area. So, but the floodplain is an area that can help identify, and that's what we're proposing to take comment on, that it's adjacent to the other traditional water. So I want to be really clear that the entire floodplain, which may flood, is not jurisdictional. And in fact, I want to remind that agriculture is exempt from having to get permits in that area, regardless of whether it's got a wetland in part of it. So I wanted to just add to the Assistant Secretary's comments on that.
Well, and a great concern to me, because I've seen it happen firsthand in Pennsylvania, where I just talked about the Corps. We have I believe it's an EPA field office up in State College, Pennsylvania, that's staffed with, what used to be staffed with, I don't know who's there today presently, with people that are extreme environmentalists, and they will interpret the law differently than the folks in Washington. And I said, look, the Corps, what's happening in Baltimore versus what they do in Arkansas or other places of the country doesn't conform to what the rule is necessarily. It's an interpretation, and that happens. I think I'm willing to bet that everybody in this room has faced that before, where the local office, whether it's the regional or the district office, is looking at things differently. And so how can you protect the stakeholders against that occurring?
Well, I'll let Assistant Secretary Darcy answer for the Corps, but we both have regional structures, as you point out, and it is important for us to develop consistency and predictability there. That is a high priority for both of us, and we view the work we're doing in this rule, and when we get it finalized, to help us provide that consistency.
Have you experienced that in the EPA, where you've seen regional directors look at something very, very differently?
Well, to the extent that we can practically I mean, there's always different opinions in any organization. Our objective is always to try to reconcile.
That's my point. What you're trying to do is, we're trying to do, as we always try to do in Washington, is a one-size-fits-all, and then what you have is you've got differences of opinion. And that causes tremendous problems for people out there trying to earn a living and farm the ground and run their businesses.
You've hit the nail on the head of that. We have to find a way to have enough predictability and consistency so that there isn't vagaries of different opinions all over the country, but at the same time, we can't be so constrained, in a one-size-fits-all world. So what we're trying to do is get that right, so we have definitions here and practice that will be established that can deal with the different situations in the country.
Well, and I know I've extended my time, but just a final point, because I think Chairman Young made a very good point when he asked, or a very good question he asked you, is there one state out there that has said, this is really good, we embrace it? And I'll let you finish answering the question.
I am sorry about that before. I really apologize. But let me just say, draining a pond does not require a permit. just if I could have answered. But the filling it would require a permit under the federal law. The state organizations have been very supportive. You know, the Environmental Council of the State, some of the other water organizations that represent state water, they've been supportive as we've been building this, but we have yet to get any specific comments on the rule from states. So I can do a polling of them, but I haven't done that polling yet because we plan to do significant continued outreach with them between now and when the comment period is over. And I want to point out that we treat states differently than normal commenters because they are co-regulators with EPA. So that we're going to be working with them differently, although they will be submitting comments.
And again, our DEP in Pennsylvania, over the past couple of years, hasn't seen eye to eye with the Corps or EPA. And back when there was a different administration, they saw eye to eye. So again, this is the problem that we're going to face: is this rule is going to go into place with all these? There's a lot of vague terms in there. And what's going to happen is these stakeholders, and we're going to have them up next year, talk about the damage it's going to cost them. And again, to your point about it not being against, you don't have to get a permit to drain a pond. Can you put that in the rule to make sure we're clear on that? So when Chairman Young tries to drain his pond, he doesn't have to come get a permit.
I think we can make that more clear.
I yield back.
Thank you,
Chairman.
Mr. Trustee, just to make a comment. What we're hearing from the state EPAs, they're concerned because they haven't been consolidated enough on this proposed rule. So, point of information. Mr. Nolan, do you have questions?
Thank you, Mr. Chairman, and thank you to the panel. First of all, I'd like to respond to my good friend of over 40 years, Don Young, who's so shy and reticent about expressing an opinion. I, too, have a farm, and we have a little pond on it that my wife and I created. It's quite beautiful right alongside the house. I suspect that that would not be covered by jurisdiction. And the courts have ruled that we don't have unlimited control over those waters that are navigable and have, so we have a river flows through my farm as well. And the courts have ruled that we have no right to dump toxic substances and other things into that river that would be harmful to people downstream. So with all due respect to my good friend, there are some constitutional and restrictions and limitations. As to the proposed rule, I will reserve a final judgment until I've heard all the facts, but I do want to applaud you to the extent that you do try to give us some predictability and some consistency here. That would be very, very helpful to many parties. I have a couple of quick questions. I'll try to be quick with them, and please be quick with your answers so I can get as many of them in as possible. First of all is I have a company that's talking about investing $3 billion in my congressional district. And my question of you is, how do you think that the jurisdiction that's proposed in this rule combined with EPA's retroactive and preemptive 404 authority in action, how do you think that impacts a company looking at making a rather substantial investment?
Well, I don't know if what they're proposing is going to impact water or not. But
pretty hard to do anything in Minnesota without impacting water.
So I'm just going to say at a high level, I think the Army Corps of Engineers through the permitting process have authorized over 2 million permits and activities under this section of law, and 13 have been involved with the so-called veto, which is essentially EPA designating a section of water that can't have a discharge of the fill into it. So it is an extremely rare occurrence that gets used, and there's a significant amount of work and process that goes on for it. So I would think in the normal realm of activities, you're talking about projects that go through the permitting process, they get permitted, they may have to do mitigation. That is some of what our economic analysis has shown, that there may be some of that. But generally speaking, I don't see that as a deterrent to business.
Well, as someone who spent the last 32 years of my life in business, I can tell you the prospect of that has a very chilling, dampening effect on anyone considering any kind of a substantial investment. And with regard to the Constitution, it raises the whole question of due process for companies in that kind of a situation. My next question is with regard to the trail system, snowmobilers, cross-country skiers, snowshoers, and unfrozen waterways and wetlands that provide some multi-use recreational opportunities for individuals. How would these regulations impact them?
I don't believe the proposed rule would change the current status of what would be required under the current law.
Is that your understanding as well? Farmers continue to ask, who is ultimately in charge of enforcement? EPA, Army Corps? Who's going to do the enforcement here?
If someone has a Department of the Army permit for an action and is in violation of that permit, it would be the Army Corps of Engineers' responsibility to either ensure that that permit is being undertaken as agreed to. So it would be our responsibility.
Well, what if the EPA determines it's part of their jurisdiction? I mean, who does the enforcement then?
Obviously, these things get very case-specific. We have somewhere in the vicinity of 30 cases a year, 30 to 40 cases or so a year that we end up getting involved with as well.
Well, what do you do in those cases where, the Army Corps has one definition and the Natural Resource Conservation Service has a different definition, and you're compliant with one and non-compliant with another? I mean, what kind of methodologies or matters for resolving this do you have in place?
Can I just explain about the interpretive rule that accompanies this proposed rule that deals with the National Conservation Service regulations and practices? We are exempting about 56 of those practices from any kind of Clean Water Act permitting requirement in the interpretive rule that we put out at the same time as the proposed rule. So it would be the National Resource Conservation Service and those local agents who would be responsible for assuring that the practices undertaken by that farmer or silviculture or rancher were being complied with.
Okay. And lastly, what kind of outreach do you have planned to help get the word out of what, in fact, all this is and isn't?
We've conducted a number of conference calls, webinars, I think over 64 to date since the issuing of the proposed rule, and we'll plan to continue to do that throughout now. Now that its comment period's been extended, we may try to increase those outreach efforts between now and then.
And then my last question, we've heard a lot of questions here about the states. What do you think these actions or how they will impact the ability of state and local governments to exercise their authority with respect to land use management and planning?
These jurisdictional determinations will still, they don't impact their local authorities other than if they are looking to do any kind of development in a waters of the United States, they would need to look to see whether that water is jurisdictional and what sort of permit would be needed by the.
Will they supersede state plans in any manner?
Not land planning, no. Okay. That's local planning and zoning.
Okay. Thank you, Mr. Chairman. I yield the balance of my time.
Mr. Crawford.
Thank you, Mr. Chairman. Secretary Darcy, you stated earlier in the course of answering one of the questions that one of my colleagues asked, in the proposal, we define. And you've also used a personal possessive pronoun. I'm a little confused. Whose proposal is this?
It's the administration's proposal.
The administration?
Yes.
So have you been working with the administration to develop the proposed rule?
Yes, EPA and the Corps of Engineers have developed this rule together.
Okay, but this is an EPA proposed rule, correct?
No, it's the administration's rule.
It's administration proposing that?
Yes.
Okay. But you've been collaborating with the Corps, with the EPA, rather?
Yes, sir.
Okay. We're currently in the public comment period, correct?
Yes.
Have you submitted public comment?
No.
Okay. Do you intend to submit public comment?
No, we intend to review the public comment with the EPA.
Collaboratively?
Yes.
Okay. I was just a little confused by that. Administrator, can you define a ditch? I just want to get some clarity. And if I apologize if I'm repeating myself, but could you give me some clarity on what a ditch is?
Well, I mean, what we've tried to do in our proposal is make it clear of that ditches that are built on land that is normally dry and somebody puts a ditch through it to drain it from rain or some other wet event and it's got water in it sometime, that these are not covered no matter what.
Okay, so here's the problem I have with that.
Okay.
Ultimately, that ditch is designed to drain water. It's going to drain into something. At some point, it drains into a body of water that is regulated and then therefore becomes regulated. Is that not correct?
So the reason we're doing the rulemaking...
I've only got 5 minutes. Is that not correct?
I understand. But let me answer, please. If you just look at the definition of significant nexus, you might start getting into those kinds of thoughts. So what we did in the rulemaking is we specifically, by rule, are excluding those, no matter whether they meet a test or not. And I think that's a key important factor.
We had, in the last 2-3 days in my hometown, we've had about 14 inches of rain. Got a neighbor, got a swimming pool. Swimming pool overflows, can't handle too much. Water flows into a ditch, ditch flows into a regulated body of water. How far back does that swimming pool become a regulated waterway?
It does not. It is not a wetland, nor is it
You don't think
stream.
that's much of a stretch, though, do you? I mean, to
No,
think that...
I don't. I think it is a stretch.
Do you really? Because the ambiguity that I'm hearing from all this is so great that I don't think that's a stretch at all.
Artificial lakes, ponds, swimming pools, they're specifically excluded. We're writing
up
them in
to the
rule.
point that they overflow into a ditch that drains into a regulated body of water, at which point they become connected, correct?
Go ahead.
I would say that's not a significant nexus.
Okay, well, I'm not sold on that, but at any rate, so what about flooded rice fields? At some point in time, they're going to drain into a flooded rice fields.
Rice fields are not included.
Well, I think what's going on here is an effort to create such ambiguity that you're given ultimate regulatory authority on a whim, and that there's really no recourse for those folks that are affected, and the finding that's going to come through in farmers and other businesses, the cash flow that it's going to impact, and there's not been any economic analysis to address that. And let me ask you one more thing about public comment. Will you be entertaining public comments from other federal agencies?
Yes.
You will. And you think that's appropriate?
Yes, most rulemaking...
Are they more heavily weighted than public comment from, say, some of the relevant stakeholders in the private sector?
No, sir.
Our friends at Farm Bureau, for example, National Association of Counties, will they be given equal weight, their public comments?
Yes, they will.
I think you'll find when you hear their public comments, and I would also echo the sentiments of the chairman, encourage you to stay around and hear their comments and find that they probably agree with me that there is significant ambiguity in this to cause great concern, not just in the agriculture industry, but to homeowners, to business owners, and anybody that has even a view of water from where they're standing. So with that, I yield back.
I'm going to take 14 of your seconds just for a clarification. You know, he talked about the vagueness, ambiguity. You know, that's why you're saying it, but doesn't this open up for citizens' lawsuits if they don't think that how they interpret the rule and litigation?
Here's where we can work together. We've tried to list these things specifically in the rule. Rice growing is specifically listed as excluded. Normal agricultural activities
we'll
are
get into that
excluded.
later.
So if we could, you know, we expect to hear from the stakeholders during this proposal and comment period time if we've not done that enough here, and then we can sit down and talk to them. But our intention is to get it in here so that
we'll talk later about this, the rest of the Clean Water Act effects other than 404 permitting. Ms. Edwards.
Thank you very much, Mr. Chairman, and thank you very much to our witnesses today, and especially for your honorable public service. I think there are many of us in the public who really appreciate both the work of the EPA and the Army Corps in protecting our water and making sure that it's clean. So thank you. I just want to clarify, the notice of the proposed rule was issued on April 1st. My understanding is that because you heard from agricultural groups and other stakeholders that there wasn't enough time to respond adequately to the rule, that's the response time for comments has been extended to October 10th. Is that correct?
Actually, it's been extended an additional 90 days till October 20th. Actually, 91 days because 90 days falls on a Sunday. So
Great. Thank you. So hearing from those stakeholders, you took that into consideration and you've extended the rule?
Yes.
The comment period. Thank you. And then, so is it a surprise to you that you've not yet heard formally from states whether they support or oppose the rule because there hasn't been a chance yet, and that it's probably preliminary to qualify, quantify, or to characterize the support or opposition to the proposed rule at this stage?
I think that's correct.
Thank you. And then, Mr. Chairman, I have 3 letters to this committee urging the Congress to enable the EPA and the Army Corps to go through the process of the rulemaking rather than create legislation that is unnecessary to respond to what has been, a very an environment in which people have been quite uncertain about what it is that their responsibilities are for permitting, and I'd like to enter those into the record. It's a letter from Clean Water Action, from Trout Unlimited, and from 15 sportsmen and conservation groups supporting the process and saying themselves that they probably plan to submit comments.
So ordered.
Thank you. I have a question, Mr. Persiasepi. Can you describe the exemptions that exist in the Act and in your proposed rule for discharges associated with agricultural activities? And in the event that certain agricultural activities don't qualify for an exemption, am I correct that the Army Corps has a fast-track nationwide permit that authorizes an assortment of discharges associated with agricultural activities that cause the loss of less than half an acre of water bodies?
Yes, we currently, that's our nationwide permit program, and that's correct.
Yeah, and just as a general matter, the normal agricultural activities of, essentially, for me, I could say if you're on a piece of land and you can plow it, plant it, and harvest it, you can do it under this rule. There's nothing in here that's going to change that.
Thank you very much. We recently enacted, in fact, the President just signed yesterday our Water Resources Reform and Development Act, and we included for the first time provisions that I've been quite a champion of using innovative green and low-impact technologies. We may hear testimony later that suggests that somehow those green infrastructure activities would then fall under the purview of this rule. Do you have a sense of that?
We don't believe that that will happen. It is not our intent, and of course we're going to be interested in comment on that. But most green infrastructure that I'm familiar with in an urban setting is going to be built in a place that is normally dry, and you're moving drainage to it. There may be instances where somebody wants to utilize an existing stream or a lake as part of that, and then we would have to look to see whether that's part of the waste treatment exemption or whether or not there would be some. But again, you don't have to worry about this unless you're discharging fill or pollution into that water. If you're not discharging pollution into the water, you're not going, or fill, you're not going to have to get a permit or be under this jurisdiction. So we would think, and it certainly is our intent, that drainage in an urban area and how it's altered to have green infrastructure and low-impact development would not become jurisdictional and would not be jurisdictional, just as we were talking about ditches earlier.
And so obviously those kinds of activities are actually designed to filter the water, not to contribute to the pollution.
We absolutely want to encourage conservation work on agricultural land, and we want to encourage low-impact development in urbanized areas, including green infrastructure. Absolutely want to do that.
Thank you. And then lastly, I understand the rule, if it's finalized, would protect roughly 3% more waters than are protected today. but almost 5% fewer waters than were protected prior to the Supreme Court's 2001 decision. Is that correct? And does that sound like an unprecedented radical expansion to you?
Those numbers are correct, and in my view, it is not a radical expansion.
Thank you.
Mr. Denham?
Thanks, Mr. Chairman.
Like the gentleman from Minnesota, I'm also a farmer. But unlike him, I cannot hope and wait to see what you guys are going to come up with. I can't take hope to the bank. And so I'm very concerned about this. It affects the livelihood of our community, of our state, the largest ag state in the nation that is feeling some of this pain already due to Army Corps and some of the challenges they've already put on some of the fallowed fields that are now having some water on those fields. And I'm concerned that this year, because of government, when water gets shut off to the Central Valley, 1 million acres of farmland could be lost. Now, it might rain next year, and we may have, with the fallowed fields, may have some puddles that, or ponds, that, or even some streams that end up going through 1 million acres of lost productivity, of lost jobs. So, yeah, I've got a lot of questions about this. Let me start with you, Ms. Darcy. Because of the ambiguity of this rule, do you think it's going to encourage third-party lawsuits?
I actually think that this proposed rule will bring additional clarity to the jurisdictional determinations that are necessary under the Clean Water Act. So I think with additional clarity, there will be fewer lawsuits.
So you think that this new rulemaking will create less lawsuits?
I do.
And greater clarity?
I do.
Now, the permits that are going to be required, how long do you think it'll take to issue a permit?
Congressman, it depends on what the permit's being asked for, you know, and you know how much information we have up front for that particular permit. It does vary. It varies from region to region. We try to do our permits, whether it's we have individual permits, we have nationwide permits. Nationwide permits are usually go more quickly than individual permits because individual permits usually require more data and more information.
If it's a area of farmland that's been historically farmed but may have sat fallow for a year or two and now is required to do a permit, how long do you think it would take to do a permit?
Congressman, what you've described would be prior converted cropland that is exempt from the Clean Water Act.
Well, I will circle back around with you because I've got a number of constituents that have these very same concerns today, that are unable to farm, that are losing a season of planting, that can't go back through and farm that property, and again, seeing that job loss in our community. Let me ask about the Clean Water Act. In 74, when this was originally done, it was done with navigable waters with ebbs and flows of the tide. Now we're seeing ebbs and flows on our riverbanks because of discharges from government forcing discharges. What we see in the Central Valley are these pulse flows. These pulse flows not only go down the river, but they overflow into the farmland that is adjacent to it, sometimes losing the crops, but sometimes forming a pond or a puddle or a mud hole that now could be under this very same thing. So my question is both on navigable waters as well as intrastate waters, where now EPA and the Corps would have jurisdiction over.
Under current law, we have jurisdiction over navigable waters.
Intrastate waters?
Yes?
What about groundwater?
No.
Mr. Presepi, you talked about pollution. Is fertilizer a pollution?
Properly applied?
Probably.
No.
What about pesticides?
Pesticides require have to be applied according to the label, and they would fall under a general permit if they apply it on water.
So again,
but not when a field is flooded. If I can think where you're going, that would not.
That's exactly where I'm going, and that's the concern that a number of our farmers have.
It would not change. That would not change because a flooded field is not is not jurisdictional.
Yeah, but if you fallow a field and you're unable to plant for a year or 2 years or 4 years, and a pond or a small, something that is already covered under your own definition now gets pesticides or herbicides or fertilizer in it, that would be a pollutant, would it not?
Boy, the general permit for pesticide application under the Clean Water Act requires the avoidance of spraying directly on waters. If there is a crop and you spray on the crop, it does not need a permit, or it does not fall under that.
So it would fall under that if you were spraying your crop and it went into that water, even though it's not into a river or a stream, but it was considered an adjacent water on a farmer's field.
The water on a farmer's field is not jurisdictional.
Not if it's flooding, but if it is accumulated water, it is under this definition, would it not?
I don't think so.
Well, then why couldn't you answer Mr. Young's question about a pond? I mean, we're talking about farmland here.
I would have answered Mr. Young's question, but I didn't get a moment. That's all. I don't mean anything by that. He could drain his pond if he wants to. Doesn't require a permit from under the Clean Water Act.
Thank you, Mr. Chairman. I got a number of other questions, but I'll wait for the next round.
Ms. Napolitano.
Thank you, Mr. Chairman, and I'm glad that we have such great agencies that help our communities, especially in California, where we really need you. Administrator Persiepi, it was indicated that the proposed ruling does not impact ephemeral waters that may exist only when the rainstorms occur, especially like in Southern California. But the concern specifically is if the water that may fall as rain is temporarily captured in groundwater retention areas, would that water be classified as jurisdictional? And this is really an important issue because of the drought and the fact that we're trying every methodology to capture more water and infuse it back into the aquifer.
First of all, we explicitly make sure to mention that groundwater is not included here. So, but second, there's no change from the existing law. So
well, that's
those
for
practices,
groundwater.
Yes.
I'm talking about captured water for replenishment.
Right. So if this activity is currently going on, whichever way it is, we're not changing any existing jurisdiction in that regard. So we want to encourage, good capture and recharge.
Well, there's so little rainfall in Southern California, the episodes may be very few and far between.
Yes, I think both of us are pretty familiar with the
Thank you.
the
And also, does the wastewater exemption, pardon me, clearly include water recycling projects? Is there or should there be a clear exemption granted for water recycling projects, especially in the western states where the drought is so critical?
So we don't think water recycling projects that are existing today are covered, and we're not trying to change that. But so if it's not regulated today, it won't be regulated under this rule. But if your folks have comments on this so that we can be clear about that, we would work on that.
Well, we certainly would hope that we'd be able to clarify that, because this is one of those issues that is not going to be ignored in Southern California or in California or the western states. The other area that I have a concern about is the stormwater discharge regulations that are going to be imposed on communities by EPA.
Stormwater?
Yes, the discharge going into the stormwater and catch basins going down to the ocean.
So under another part of the Clean Water Act, areas that have stormwater runoff are required to get a permit, and under Section 302 of the Clean Water Act, and most of them have those permits. Then require either green infrastructure or some other maintenance activities to make sure that pollutants are minimized. But
well,
there's no change to that in this rule.
Okay, well, I may want to clarify that later, if I may,
Okay.
because
Yes,
there's
yes,
an
ma'am.
issue that some of the cities have raised concern. It's an unfunded mandate for them to be able to ensure that no contaminants go into the drain systems for stormwater release.
Okay. I'm happy to follow up with you on that, but we're not trying to change the stormwater rules in this regulation. But if there are issues with stormwater, I would.
If you wouldn't mind,
Yeah,
yes.
absolutely.
And I certainly want to thank Ms. Darcy Your folks are tremendous in my area. They work with all my agencies, and we've been able to clarify and work forward on many of the issues that have issues in my area. Thank you, Mr. Chair. I yield back.
Just some housekeeping here. I ask unanimous consent that Mr. Duncan from Tennessee, who's not on this subcommittee, be included in today's hearing. Without any objection, so ordered. Mr. Mullen.
Thank you, Mr. Chairman, and thank you both for being here. I know we have met actually on separate occasions, not always on the best terms, but we're all fighting for the same thing, hopefully this country, and the right to still be entrepreneurs. I think what the biggest fight is here, though, is that we seem, as business owners, as farmers, as I said in front of you, I'm farming the same land that now is the fourth generation. And it seems like every time we turn the corner, what we're doing is we're asking more and more permission to just simply do the same job that we've always done. I think you're going to find it very hard to find somebody that's got more interest in their water than the person that's owned that land since before statehood. But the way the definition is wrote with navigable waters, I'm finding it very hard to understand, ma'am, and maybe you can clear it up to me, how a stream gets into that. Maybe just simple-minded individual from Oklahoma that's been blessed enough to be able to be a congressman, navigable waters would be at least something you could put a canoe on.
Congressman, navigable waters has had, since the inception of the Clean Water Act, had a great deal of attention and litigation as well as court decisions.
I'm well aware of those, but I'm just trying to figure out how you guys feel like you have to come out with clarification when it's pretty clear itself. And what we're doing is we're going farther up the streams and making the definition even more confusing, and we're taking rights away from the states. Sir, you had made a comment that you said the state water boards you felt like was on board with you. If I understood that, because the question that the chairman and Congressman Young had asked you was what states support you, and you made a statement that the water boards of the state support you.
I said that some of the organizations that represent states, their water associations, have supported doing a rule.
Who?
We don't have.
Because I've got the gentleman from Oklahoma sitting that's going to be testifying on the second panel, and no one contacted them. So who is it that you said is supportive of you? Because if we're going to try really taking in the waters and having the best interests of the landowners, the people who pay the tax to own that land, the people who live in that state, wouldn't you think you would take the time to comment before you made this, not requiring them to come out afterwards and make comments? When I find it almost laughable when you guys are going to have these comments out, which really isn't going to have that much impact. You might add a thing or two, but the rule's already out. You've already made your mind up what you're going to do. Otherwise, you would have consulted them beforehand. Is that not correct?
We did talk to states. I can't say we talked to every state. Well, here is a list of state associations who have asked us to do a rulemaking. They don't necessarily support this rulemaking yet because we don't know what their position is yet, and we're going to work with them before we finalize.
Then you should have had that before you went out with it. That's what I'm trying to understand. Now, let's go back to the farming just for a second. The way I read this is you guys are going to accept existing permits. It's not going to change existing permits. Is that not correct, ma'am?
That's correct.
Okay, so now what about that existing permit? What happens? Does it stay with the land, or does it stay with the holder of the permit? Say my father, which I'm not hoping he does by any chance, but say my father owned the permit and he passed away and had to be transferred to myself. Is that considered an existing permit still yet?
If it's applied to the land that it was permitted on, but
the land has essentially changed hands, so the permit will change hands too.
I believe it goes with the land.
You believe? Because it doesn't read that way.
Well, and that clearly...
It doesn't read that way at all, and there needs to be clarification on that, because I can tell you, I've read it, and the way I read it is that every time we lose a generation and the farm changes hands, which you know, farms are generational, we're going to lose farms as this happens.
Congressman, most agricultural practices are exempt from the Clean Water Act.
Most, ma'am, there's still permits because you had enough worry about it that you put in it that existing permits, it specifically says existing permits. So we keep using this that most are exempt. Actually, what was first said was, sir, you said that all ag is exempt. Now we're to most.
All normal agricultural activity.
Normal.
Regular.
What is
you know,
considered
plowing,
normal? Because what I
planting,
do isn't
plowing, and
considered normal.
harvesting.
You guys
Those are
already
things
came
you do.
into my land and said we couldn't spread chicken litter anymore. That was on my property. You guys came in on my property and said we couldn't spread chicken litter anymore, effectively killing the chicken industry around for the small business owners. So I don't want to hear that anymore about normal. Normal is what? How many farms have you been on? How many times have either one of you guys worked on a farm? What is normal in Washington, D.C.? There isn't one thing in Washington, D.C. that is normal. Not one.
Well,
so I don't want to hear the
talking about
normal. What I
Washington.
want to know is how are we going to protect generational farms?
Congressman, if there's ambiguity in the proposed rule about existing permits and how they will be transferred between either the current permit holder or the future of that land, I think that's something we need to clarify.
Yes, we do. Please, if you could, get with me on some clarification language on that. Thank you.
Mr. Garamani.
It's interesting that we ended with chicken manure. Mr. Pucciaseppe and Secretary Darcy, I personally thank you for your efforts to clarify a long-standing controversial issue that has been with this country for well over 40 years now. And that is the application of the Clean Water Act. You've had a very, very difficult task because of the Supreme Court interpretations of the law. You've been left with the necessity to provide clarification. And it's my understanding that this effort, this proposed rule, is a result of the necessity to clarify the application of the Clean Water Act. If I'm correct, am I correct, and could you briefly describe, very briefly describe, how it is that we came to this proposed rule and its purpose?
Congressman, the purpose of the proposed rule is to clarify the ambiguities, many which resulted from the Supreme Court decisions and the Supreme Court directing us to develop a rulemaking for this purpose. We coordinated between the agencies, EPA and the Corps of Engineers, to develop what we think is a proposal that will do just that, to give people clarity, hopefully more efficiency in this permitting program, and the ability for people to know what's jurisdictional and what's not.
So the purpose and the goal is to provide clarity.
Yes, sir.
Apparently, that has not yet been achieved, at least among the members of this committee and a good portion of the public. How are you working now, beyond explaining to this committee, the process of achieving clarity? We're in the midst of a rulemaking. Can you describe to all of us what you would expect the public to do if they believe there is uncertainty in your regulation?
Through the public comment period, which as it now goes until October 20th, we would anticipate that concerned citizens who have comments on this rule, whether it's not clear enough or the definitions aren't what they believe to be representative of how we should be regulating waters of the United States, we anticipate that to come through either public comment via, we have a website set up for public comment. We also are having webinars and conference calls with interested stakeholders and groups around the country to get their input and get their comments that way as well.
Mr. Pucciaseppe?
Well, we're also doing additional specific outreach, and I think one of the things we're developing now with the extended time period is additional, more focused outreach as well. We've met with a lot of people. We have a roundtable with small business, with the Small Business Administration coming up on June 24th. We're going to have a specific process with our co-regulators at the states in terms of of the implementation of the Clean Water Act, because once you decide where it's jurisdictional, all the implementation, a lot of the implementation takes place at the state level as well. So we expect to have quite a bit of additional outreach through the summer.
Okay. Does your website provide specific opportunities for various locations in the country for people that are concerned about the lack of clarity in the rule to make comments?
Yes.
Okay. Can you provide to the committee those specific sites and locations?
Yes, we can.
And efforts that you are making to reach out to agriculture, chicken growers, or whomever, as well as wastewater and drainage systems across the nation. Finally, it's important that we understand that we are in a rule-making process. You have proposed a rule. Is it the final rule?
No, sir.
Okay. Are you committed to listen carefully to the objections, some of which you have heard here today, others of which I suspect you'll hear in your process, to take them into account and to modify, where appropriate, the ambiguities and to clarify? Is that your commitment to do that?
Yes.
Mr. Pucciaseppe?
Yes, sir.
Okay. And you are representing both the Corps of Engineers and the EPA, is that correct?
Yes.
I'm EPA, she's the Corps.
I got it. Now, it's important for all of us to realize where we are in this process. You know, I've got a lot of folks in my district. I have a large agricultural district. I've got plenty of water, like 200 miles of the Sacramento River Valley, including the river, and a lot of questions. When my constituents come to you with asking for clarification, will you listen to them? And will you take that under advice and, if appropriate, make modifications?
Yes.
Okay. Now, finally, clarification is one thing. There is the law, and there are certain thresholds that you will have to follow, I suspect. That then becomes a court question. Is that correct? A question for the court to answer.
As to whether the rule complies with the underlying law?
Okay.
Yes, ultimately.
Mr. Chairman, thank you very much.
Okay. Mr. Meadows.
Thank you, Mr. Chairman. Thank you both. I do want Ms. Darcy to give you a chance to respond in terms of those permits that supposedly transfer. I assume you have counsel here. I would give you a chance to revise your statement because I can tell you from real experience, I don't think that your testimony was accurate. If you've got counsel in terms of if there's a transfer of land, transfer of permit, you know, perhaps you want to do that. Is that your counsel leaving? Okay, all right. Well, you can get back to the committee. I've got limited time, but it is not accurate, and I would just encourage you to get together and perhaps change that. But let me go on.
That's why I responded to the chairman. I mean, to Mr. Congressman Mullen, that if it's not clear, we need to make it clear. And
well,
maybe I need to be clear.
It's clear that it doesn't transfer, and so and your counsel's nodding his head yes. So I would just encourage you to revise your statement. So the other part of that is we're implementing these rules for the health and safety of the American people. Is that correct?
Yes.
Okay. So, Mr. Persepi, do you have adequate funding to make sure that the current rules and regulations that we have are implemented and carried out to provide for that health and safety, current funding? Yes or no? Do you have adequate funding?
Yes.
For the current regulations?
The one on the books?
Everything that's on the books without a change?
Yeah.
So everybody should be safe today?
I'm not exactly sure what I mean, we implement a lot of different laws that Congress has passed, but...
Okay, well, let me go on further then. With this rule, any rule that an agency makes is really for the sole purpose of carrying out the intent of Congress's law. Would you both agree to that?
Yes.
Okay.
Yes.
So since the administration came up with this, at what point did someone in the administration realize that the intent of Congress under a previous law was not being carried out? Who made that decision that the original intent of Congress when they passed the Clean Water Act is not being carried out? Who made that decision?
Well, within our agencies, the purpose, as I stated earlier, for doing this rule is to provide clarity that we think as a result of the court decisions we needed to do.
Okay, so it is your agencies that decides the intent of what Congress originally passed as law.
Well, let me just...
Because I'm part of a body of 435 people, and every day I'm confused as the intent of this body. So it's amazing how somebody at your agency could figure out what the original intent of those who passed the law would be.
I think what we're responding to is decisions that were made in the past that went to the Supreme Court, and the Supreme Court has a number of different positions or opinions that they've issued, and what we have done looking at those opinions of the Supreme Court, which have come out in the last decade, that the existing regulations that we had on the books from the 70s need to be modified.
All right, so you're ignoring Justice Alito's concurring opinion then, because he said that really Congress needs to clarify what the waters would be. And so you're taking Justice Kennedy's sole opinion and ignoring the other 4 justices?
Well,
I
believe the Chief Justice has opined on the fact that the executive branch should do something
and
about
that Congress needs to weigh in as well.
No, I think Justice Roberts said the executive
So
branch has had an opportunity to do that.
So you're taking Kennedy and Justice Roberts' opinion.
Well,
okay. I think my point's made, and really the whole point is that Congress should be the one that is fixing that, not administrative law, because I'm very concerned that you continue to make rule after rule after rule, and arbitrarily decide what is good for the American people when there's 435 in this body elected officials to make that decision. Would you not agree?
I don't agree that it's arbitrary, because I think we interpreted the law that Congress passed in 1972. We put out those rules back in the 1970s. Those are the rules that the Supreme Court never said they were unconstitutional, or the law that the Congress passed was unconstitutional. They just said
so you
the executive
just passed
branch
unclear rules, and we're just clarifying it, is what you're saying.
Well, people brought a case and it went to the Supreme Court. The Supreme Court said we should modify.
Let me close because I'm out of time. A little over 30 days ago, I brought up with you, Mr. Presepi, an issue with contamination in my district. I've yet to hear from you. Have you checked into all of that? We've got no response from you, and if you're really concerned about the health and well-being of the American people, I would have thought that a follow-up phone call with egregious violations within the EPA would have been appropriate, wouldn't you?
Yes, sir.
Okay. When can we expect a response from you and get that cleaned up?
You'll get something from me before the end of the week.
Thank you, sir. I'll yield back.
Mr. Jolly.
Thank you. Secretary Darcy, you mentioned that this was the administration's proposal. Is that correct?
Yes.
Who else within the administration has had input on this?
Well, it was developed with EPA and the Army Corps of Engineers.
No, I understand that, but you deferred then to call it the administration's proposal. Has somebody from the Domestic Policy Council been involved in creation of this proposed rule?
No, but the Office of Management and Budget has reviewed the proposed rule.
From a policy perspective, has anybody from the White House been involved in this proposed rule? To refer to it as the administration's proposal is an interesting choice of words. It's as though you deferred some of the responsibility of this to the administration collectively as opposed to just the EPA or the Corps?
We are part of the administration, so and we have, as I've stated, this has been also reviewed by the Office of Management and Budget, which is an arm of the President and an arm of the administration.
To the extent of your knowledge, was the Domestic Policy Council involved at all in the proposed rule? Yes or no?
I don't believe so.
Okay. Is that your understanding as well, Mr. Administrator?
I can't know specifically, but when we do a rulemaking jointly or individually as agencies, it goes through an interagency review under an executive order that's been in existence since many, many administrations ago. And in that interagency review run by the Office of Management and Budget, all the agencies get a chance to participate and comment on proposals before they go out as a proposal. So I don't have the details on everybody who may have responded or put input into that, but opportunity was availed to every agency, and we actually did some work with the Department of Agriculture to try to clarify conservation practices that would be to be clear that they are not they would not be affected by this rule.
So in drafting the proposed rule, was there any contribution of language from the White House?
I don't have any specific information on it. Interagency includes the Department of Energy, everyone else.
Okay. So you also mentioned that this is a result of some confusion from the Supreme Court decision. Is that correct?
Yes.
Okay. You seem to rely on Justice Kennedy's significant nexus definition, though, as having provided some clarity. Why the need to expand on his definition? Why not just take it as written, if you're relying on that?
Well, I think in our definition we did include significant language from Justice Kennedy, but we also recognized that we wanted to make it clear that in addition to that, we wanted to make it clear that some activities and waters were not going to be included. We talked about the ditch already, so we wanted to clarify that in the rulemaking that ditches that are in these roadside ditches, types of ditches, would not be included.
Okay.
As an example, or groundwater, or a number of other things that were not specified in his definition.
The curiosity is because, Secretary Darcy, in your written testimony today, you refer to the confusion created by regional application. And I find your written testimony interesting because it's as though the Corps embraced regional decisions as being closest to the community, best understanding the issues of the community following Swank and Rapano. And yet now either the Corps, the EPA, or the administration broadly is stepping away from that regional application because in your written testimony it's now suggesting that what was the answer, to use regional application, actually created confusion. And that's now why you're issuing this.
Well, there will be regional distinctions between other waters, but in order to have more clarity overall, I think that the clarity that this rule will provide will give direction to each of our regions as well as our divisions and our districts about how to apply this overall.
Okay, and the last question, part of the efficiency it says that you will be creating is by reducing documentation. Can you explain that? I think that's the heart of the concern of a lot of people who have concerns within their district, that now this will be a less documented, less justified, less explained decision-making authority coming from Washington, and in fact the regional office will now have less ability to address specific regional concerns.
An example of less documentation would be in the instance of the definition of tributaries. That people will now know that a tributary is a jurisdictional water of the United States. Previous to this rule, there were instances where we would have to go out and on the ground make a determination as to whether a tributary was actually a navigable water. So in this instance now, we have defined tributaries, so you, an applicant or the Corps will not have to go out and look and say, okay, yes, it is a tributary. So that's one piece of the documentation that will be alleviated by this rule.
And you're confident that streamlining is a better system?
I do. I do.
All right. Thank you very much. I appreciate it.
Mr. Rice.
I want to thank y'all for being here today. I've certainly learned a lot. I think the problem here is just the expansion of the bureaucratic authority here and the stifling effect it has on our economy and our freedom. And I wasn't here in 1972, but I sure think we're regulating as waters of the United States things that would not have been considered in 1972. And everybody's very fearful that this new rule is an attempt at further expansion, and particularly with the administration's expansion of environmental protection in other areas currently. I look at this list of, I take it the purpose of this rule is to more clearly define what the waters of the United States are, correct? And then I'm looking at the proposed definition here, and there are 6 defined categories, and then on a 7th it says, on a case-by-case basis, other waters, including wetlands, provided that those waters have a significant nexus to a water defined in paragraphs 1 through 3 of this section. And then, as you said earlier, the word significant is defined, and it says the term, you know, that's where the play comes in here. What does significant mean? The term significant nexus means that a water, including wetlands, either alone or in combination with other similarly situated waters in the region, significantly affects the chemical, physical, or biological integrity of the water. Is that correct?
Yes.
All right, so you're defining significant as whatever is significant, right? You're saying that it has to have a significant connection, it has to have a significant effect.
Yes.
Well, how does that clarify the rule? I mean, at all? Who determines what a significant effect, chemical, physical, or biological integrity, who makes that determination?
That would be a determination that would be made by a regulator on the
Okay,
ground.
so either the EPA or the Army Corps, right?
The Army Corps.
So what you're saying then is that a federally controlled body of water is anything that we determine is significant. That's very clearly what this rule says. And even if you don't read it that way, other people get involved in this, other groups get involved in this, and they want this enforced to the letter of the law. Am I correct? These outside groups can bring lawsuits based on this proposed rule, right?
Yes. Well,
So
final rule.
if they determine that it has some significant effect, then they can hold up commerce. They can invade our freedom further. I mean, that's the way I see this. Here's what worries me. All this expansion of authority absolutely affects commerce. The people making these decisions have no skin in this game. There's no cost to them. And what I worry about is we make ourselves less and less competitive in the world with every one of these additional rules. And I don't see this rule clarifying anything. I mean, you're saying a water is federally controlled if it's significant, and it's significant if we determine it's significant. So I don't see that clarifies anything, and that goes right to the crux of the rule. So here's my question to you. Y'all have kids?
No.
Okay. You got kids? You got grandkids?
Not quite yet. My daughter's getting married next week.
Here's what I'm worried about. Because I got kids too. I'm worried that when these kids get out of college, because we're telling them they'll go to school and get great education, your grandkids get out of college, that we're going to so stifle our economic freedom here that there's not going to be anything for them. I'm worried they're going to have less quality of life rather than better quality of life because of these rules. I think, everybody certainly wants to protect our groundwater, but I think we've gone so far in doing this that the marginal cost is so much greater than the marginal benefit. And I would hope that when you actually, okay, I hear you say these aren't final rules, we're just putting this out for discussion. Well, my opinion is this doesn't clarify anything. I think my office could come up with a better draft than this.
Can I just add a couple of points?
Sure.
Because you're on to the issue we're trying to deal with, and I just want to point out that earlier on in the definition section, it says, notwithstanding whether they meet the terms of the following paragraphs, including number 7, these things are excluded. And so it has a list that we've talked about a number of times already, some of the ditch issues.
Okay, you specifically excluded a few things. I understand that.
So then when you get into the rivers and the streams, there's a definition in here that if it doesn't have a normal bank, and these are defined in the science of hydrology, a bank or a stream bed or a ordinary high water mark, then it is not included. So so at some point, whether there has to be enough water occasionally in there, even seasonally, is all members of the Supreme Court pretty much agreed with there's a seasonal component to this. So there are, and then for it to be a wetland, somebody was mentioning earlier about water flowing out of a pool and across the yard and into something else. Well, if it isn't a wetland, if it doesn't exhibit the hydric soils or but I'm just pointing out that there are other factors that are involved as to whether or not.
And here's just from a big picture perspective, and I'm way over my time. I understand other factors and exclusions and all that, but here's where we are. It takes 15 years to get permission to dredge the Port of Miami. Which has been dredged umpteen times before. It's going to take 5 years to get permission to dredge the Port of Charleston, which has been in a constant state of being dredged for the last 20 years. It takes 10 years to get permission to build a road. We can sit here and dance on the head of a pin for days, and it doesn't change the fact that our regulatory expansion is completely out of control, and we need to be reining it in rather than continuing to grow it. Thank you very much.
Mr. Webster.
Thank you, Mr. Chairman, for having this hearing. I do have one question of EPA. How is EPA planning to distinguish between groundwater and shallow subsurface connections?
First of all, I think...
Because I'm asking that because Florida is kind of it's a unique state in a lot of ways. I mean, most of Florida is a wetland, and the water's close to the surface. Anyway, what do you think?
We're trying to stay out of groundwater with this rule. So if we're not achieving that, I hope we'll get some comment on that, because we're trying to exclude groundwater from being considered. We're also trying to make sure that drainage is not included as well. So,
but in staying out of it, don't you have to distinguish between the two?
Well, one, you're talking about a constructed underground system? I'm not...
Well, just there is shallow subsurface connection, and I assume that that's not the same as groundwater. And what I'm asking is, will there be some sort of distinction between the two?
There obviously is. I'm just going to read from the definitions. Excluded from this is groundwater, including groundwater drained through subsurface drainage systems. That's excluded.
So would pollutants introduced into shallow subsurface connection be in need of a permit in order to do those discharges?
I don't know this. It'd be improper for me to try to answer not knowing the issues. I mean, you can inject things into the ground for disposal, but it does require a permit under the Safe Drinking Water Act. If you're disposing pollutants or other things into the ground, there are places that do this all over the country, but they do require a permit under the Safe Drinking Water Act.
Okay. Yield back.
Mr. Massey.
Just want to start with a common sense question. I think it's common sense. This comes from my home builders. But first, let me ask, what's the cost of implementing this new rule? Just quickly, give me a range.
Our draft economic analysis, which is out for public comment, estimates between, I can look up the exact numbers, but somewhere between $100 million and $200 million.
$100 to $200 million. So are my home builders going to have to get more permits or fewer permits after this rule?
This is based on...
Or the permits just get more expensive?
This is based on the observation that Assistant Secretary Darcy said earlier, that when we went back and looked at the jurisdictional determinations made under the 2008 guidance, we saw that maybe about 3% would increase.
So you're going to increase the jurisdiction of the EPA and the Army Corps of Engineers?
No, these would be because of the...
And so that's going to lead to more cost. Here's my common sense question. There's a whole industry that tries to deal with these regulations, and I know you spend a lot of your time and resources and money, which is taxpayer money, trying to protect the environment and our waterways. Wouldn't it be more effective just to set the guidelines for the home builders to follow and not require them to get permits? Wouldn't that be more cost effective to go back to the fundamental principle in this country that you're innocent until proven guilty? Why don't we assume that they're good actors until you find out otherwise? Why does everybody have to ask Mother May I to the EPA and the Army Corps of Engineers if they just want to build a home for somebody?
Well, I would say that well, first of all, we don't expect the jurisdiction to...
I'm done with that question.
Okay.
What about the idea of just setting the rules, and if the home builders abide by the rules?
The permit that they would need would be the authorization to discharge pollutants or fill into the water.
Yeah, I'm not talking about permits. The question here is, if they don't discharge pollutants, why do they need a permit?
They don't.
Okay. So why are my home builders waiting for permits?
Because they want to fill in, I'm guessing, because they want to fill in.
But their fill is not going to cause pollution. Otherwise, you wouldn't give them a permit.
No, the Clean Water Act defines fill as a
okay, but why, if that fill is not harmful, and you set up the guidelines and they abide by those guidelines, why do they need a permit? What I'm testing here is the whole assumption that I think has been promulgated here is that these guys are bad actors and you need to rein them in and they've got to get your permission before they can do anything.
We don't think they're bad actors. We think they do amazing
I don't
things.
think they are either. They're building homes, but they can't do it in my district because they're waiting months for permits, and some of this stuff's not even developable. Look, I want to go to agriculture here. Why did you seek to narrow down to 56 the number of agricultural farming practices? Why can't we just assume the farmer knows how to farm?
Congressman, in the interpretive rule that accompanied this proposed rule, we worked with the Department of Agriculture and the Conservation Service to list 56 practices that are currently undertaken.
So you worked with organizations in Washington, D.C. That's great. But why don't we trust the farmers back home that they know what the practices are and assume there might be more than 56 things you have to do to farm?
Congressman, those 56 things are ongoing conservation practices that we are saying are exempt from the Clean Water Act that we have not said before. So these are additional new things that have come into being since the passage of the Clean Water Act.
Can you tell me what's not exempt now?
What's not exempt?
Yeah, what might a farmer do that is not exempt?
I could not tell you right now what is not exempt because most of the agricultural practices are exempt.
Here's one thing that I'm worried about. You know, I'm a farmer. I farm. I've got ditches. They've all got I could find a bed, a high water mark, a bank on these ditches. How's that compatible with excluding ditches and then saying if it has these features that it's under your jurisdiction?
We have specific exemptions in the proposed rule for ditches.
Do those exemptions extend to somebody who's spraying their fields and they've got a grassy ditch for instance, that may flow only occasionally and they're using approved ag chemicals?
That is exempt from the Clean Water Act because it's an ongoing agricultural practice.
That's comforting to hear that none of my farmers will have to get a permit, this is what you're saying, correct, to spray their fields from either the Corps of Engineers or the EPA.
That's correct.
All right, thank you. My time's expired.
Mr. Davis.
Thank you, Mr. Chairman. Thank you, Secretary Darcy, Administrator Persiepi. I have a couple questions. Number one, the administration has committed to streamlining and expediting permitting for major infrastructure projects that move energy. However, it seems that the EPA waters of the U.S. rule will do just the opposite because it creates new subcategories of water that could be subject to federal jurisdiction. Is there any way for the EPA, Mr. Administrator, to guarantee that this rule will not further delay permitting for energy infrastructure projects?
Sorry. Our view is that we're not expanding the jurisdiction, and we're actually excluding some things that may be involved with some energy development projects. So, I mean, I don't see how this will add to the burden.
Okay. I'm going to get to a few more questions that I think may get back to this. We're a little frustrated by what could be the regional approach to some of the permitting issues, and I'm going to give you a couple examples in just a second. But you also mentioned, Mr. Administrator, that in your testimony, the EPA and the Corps then worked with the U.S. Department of Agriculture to ensure that concerns raised by farmers in the ag industry were addressed in the proposed rule. Did you also consult with the EPA Science Advisory Board, which now includes, due to the Farm Bill and amendment that I introduced, agriculture interests?
Science Advisory Board,
yeah.
Did you say? Yeah, the Science Advisory Board will be looking at this proposed rule before it goes final, but they haven't completed their review, and we haven't set. They're currently reviewing some of the science documents that go along with this as well. And one of the reasons, in addition to stakeholder requests, that we've extended the time period for public comment is we wanted to complete the Science Advisory Board's review of some of the science documents so that review is out there at the same time as the rulemaking docket is still open.
All right. Another quick question on the energy side that I forgot to ask. Secretary Darcy, can you give me any idea how other agencies and industries, subjectively determine what might actually be covered by a Clean Water Act permit?
Under the proposed rule? I mean, how would they comment?
Under the proposed rule.
Under the proposed rule, anyone who believes that they would be impacted by the proposed rule can comment to us.
So through the comment process, they can come in because they might believe that they could be impacted, could be required to maybe self-report, work with their regional offices, et cetera, on an energy infrastructure project?
Yes, because then they would want to know if they would be subject to the rule. So yes.
All right. In your proposed rule, it mentions that waste treatment systems are not included in the definition of the proposed rule of the Clean Water Act of waterways, right?
Yes.
Okay. Does that change the EPA's jurisdiction over above-ground septic discharge systems that many in my district actually have to utilize because of either soil type issues or rural living arrangements?
I turned it off when I thought I was turning it on. I don't believe EPA does not regulate septic tanks.
You may want to check with your regional office that covers my state of Illinois, because above-ground septic discharge systems are being regulated by that regional office under an NPDES permit. And that's part of my frustration of maybe what you see and what you hear in Washington isn't getting to your regional offices, because members of ag interests in the state of Illinois met with the U.S. EPA just very recently, it may have been yesterday or this morning, on what are the requirements for above-ground septic discharge permits. And it said that it is the EPA, your region said it is the responsibility of the potential discharger to determine whether or not his or her system might discharge into a water of the United States. And it said, even during this self-determination, this comes from the EPA's guidance. Frequently asked questions on EPA's NPDES general permit for new and replacement surface discharging systems in Illinois, an FAQ sheet. I'll go right to the point. It says, if so, even though pollutants would not be carried to waters of the United States unless your area experienced an exceptionally wet season, you are still required to obtain coverage under a permit. Only if you are sure that your system would not discharge pollutants to a water of the United States or a conveyance that leads to a water of the United States should you forego obtaining a permit for surface discharging system. If you do not obtain a permit but actually discharge, you may be subject to an enforcement action under the Clean Water Act. This gets to the point of the rule, sir. It specifically says wastewater discharge systems will not be subject to the proposed rule and the change. But your regional office is basically saying self-report. However, we may fine you if you're wrong, because it may actually discharge according to their own rule or their own guidance. It may discharge into a navigable waterway. Can you see where we have some problems here when it comes to what you're talking to us about and then what goes back to the region and then has a tremendous impact on the families that I represent and that all of us represent here in this country?
Well, I'm at a loss to determine whether or not, I mean, first of all, this is a proposed rule, so the regions are probably not dealing with it now anyway, but we think the waste treatment exclusion has been in existence before this rule. We're trying not to change it, so I can't answer you here, and I'll find out for you why something like that doesn't fall under the existing waste treatment exclusion. I just don't know the answer to it.
Well, thank you, and I do appreciate your willingness to do so. And I'm going to end by saying this because I'm out of time. Many rural communities in Illinois, some of the poorest areas in Illinois, have to rely upon an above-ground septic discharge system. And it is an issue where they can't be worried about the EPA determining whether or not there's going to be an enforcement action based on this NPDES permitting process that seems to be so vague and seems to be in direct contradiction with the proposed rule. So thank you for getting back to me. Secretary Darcy, thank you for your time too, and thank you to both of you for being here today.
Okay, we're going to conclude this first panel. I want to thank you for coming. I just got a comment. It's really amazing to me, and really appalling, I guess, that this proposed rule has been put out and the connectivity study hasn't been completed. And when you hear all the questions and everything, you know, what is the jurisdiction? What includes, you know, its tributaries, ditches, tributary ditches, and all that, and wetlands. And when the study's not done, and that's what I create so much ambiguity and vagueness here. And I think you really need to be concerned about that and really take note of the comments that are coming in and from this hearing. And otherwise, we're just opening up a whole can of worms and I think a trial lawyer's dream come true, and a lot of lawsuits. Well, and we don't want to have litigation to cause more problems. So.
Our objective is to reduce that, as Assistant Secretary said, and I appreciate what you're saying about the study. I mean, we had the draft study when we did this rule, and that's one of the things we promise we will not.
I don't believe it was peer reviewed. I don't think it's gotten to the finalization.
Yes, it had two prior peer reviews before it went to the SAB. So we can get into that detail. I know you're out of time, but we won't finalize the rule without their final review.
And I know you've been here for a while. I hope you can stay and at least hear the testimony of the next witnesses, because I think they've got some really good comments and raised a lot of questions of where we move forward on the.
We look forward to working with them over the next 90 days.
Thank you, and we'll take a couple minutes here to get set up for the next panel too.
you can tell.
I got to tell. Well, I noticed that's what
Yeah. Had nothing to do with that. He's got himself a good racket going.
Huh?
He's got a good racket going.
I guess so.
That's right.
That's great. Okay, the committee will come back in order. This time we welcome panel 2, and I'm going to yield to Mr. Mullen from Oklahoma to introduce the first witness.
Thank you, Mr. Chairman, and it's a great opportunity I have to welcome Oklahoma's own J.D. Strong, who is the Executive Director of the Oklahoma Resource Board and also a fifth-generation farmer from Oklahoma. He has a very unique perspective. He even got his education at the Oklahoma State University, which, as long as it's in Oklahoma, it's pretty good. We keep it home. But you know, J.D. has a very unique story to tell with the challenges that his farm and his family has went through year after year after year, and the challenges that each generation has faced. At the same time, he brings a point of view from the state. And it really is important to understand that the state has a lot at stake at this. And when you have a gentleman that's so deeply rooted in Oklahoma, and he is in a position and thought of enough in the state to be appointed to this position, we should really value his opinion. He's bringing it from not only the political standpoint, but from a personal standpoint. So, J.D., it's good to have you here. Wish the hair was a little kinder to you, but you know you can't have all things and have the pie at the same time, right? So, thank you for being here.
I'd also like to welcome Mr. Pfeiffer. He's the manager of the Southern Delivery System of Colorado Springs Utilities. He's on behalf of the National Water Resources Association and the Western Urban Water Coalition. We also have a Mr. Dusty Williams. He's a general manager, chief engineer for Riverside County, California Flood Control and Water Conservation District. He's also testifying on behalf of the National Association of Counties and National Association of Flood and Stormwater Management Agencies. We also have Mr. Bob Stallman. He's president of the American Farm Bureau Federation and Texas farmer that I've known for many years. Good to see you, Bob. We also have Mr. Kevin Kelly. He's president of Leon Weiner and Associates Incorporated. He's the National Association of Home Builders. And we have Mr. Eric Henry. He's president of TS Designs, and he's here on behalf of the American Sustainable Business Council. Welcome all, and Mr. Strong, the floor is yours to give your opening statement.
Thank you. Thank you, Mr. Chairman, Ranking Member Bishop, and members of the committee for this opportunity to testify before you today. On behalf of the Western Governors Association and Western States Water Council, a couple of nonpartisan organizations, independent organizations representing the governors of 19 Western states, I serve as chairman of the Water Quality Committee on the Western States Water Council, and appreciate this opportunity to discuss concerns regarding the Clean Water Act, Waters of the U.S. proposed rule by EPA and the Corps of Engineers. First, we recognize that the EPA and Corps of Engineers actions have significant effect on states, not just in the West, but across the United States. Therefore, it's extremely important that states be regarded as full and equal partners, in fact, as co-regulators under the Clean Water Act, as Congress intended for both the states and EPA to implement the Clean Water Act in partnership, delegating much of the authority to states to administer those laws as they see fit within their respective states. And in this particular case, the Western states at least are unanimous in their concern for the fact that the states were not adequately consulted in advance of this rule being proposed. While there were communications, status reports, so forth, as co-regulators and the ones that will be faced with much of the burden and cost of implementing what happens to waters of the U.S. Across the United States, not being involved in that rulemaking process and actually drafting the rule is of great concern to the states, and of course has led to much confusion here on the back end of the rulemaking process. As we noted repeatedly in our letters from the Western States Water Council, waiting until the public comment period to solicit state input does not allow for meaningful consideration of states' views as well as alternative ways the states may have for meeting federal objectives under the Clean Water Act. We also urge the agencies to recognize the federal federalism implications of this particular rulemaking, particularly noting Executive Order 13132 that requires a higher level of consultation with states where federalism implications do impact the states. And in fact, in the preamble to this rule, the EPA and Corps of Engineers say, I quote, this rule will not have its substantial direct effect on the states, on the relationship between the national government and the states, or on the distribution of power and responsibilities among the various levels of government. Of course, nothing could be further from the truth, because the very goal of this rule is to define where federal jurisdiction stops and where state jurisdiction begins. Nothing could have more of a direct and substantial impact on the balance of power between the federal government and the states. We reiterate what Governors Hickenlooper of Colorado and Sandoval of Nevada, as chairman and vice chairman of the WGA, said in their March 25th letter, that the agencies should consult with the states individually and through the Western Governors Association in advance of any further action on this rulemaking, and would also reiterate concerns that the Science Advisory Board that is set up under EPA to help advise this rule does not have state representation, yet there is a great deal of state expertise when it comes to these matters. 27 experts on that panel, and not one is a state agency scientist or expert. Finally, let me just jump to my Oklahoma-specific testimony with the very little remaining time that I have left, and say that on behalf of the state of Oklahoma, and not necessarily Western Governors Association and Western States Water Council, I reiterate the concerns about co-regulators not being just stakeholders, but in fact should have been involved in the rulemaking up front. Would also reiterate concerns about getting the cart before the horse in terms of not waiting for the connectivity report to be finalized, which can have a significant scientific effect on, I think, informing this rulemaking. And so it's encouraging to hear some of the words that were expressed today that this will not be finalized until then, and yet it's a mystery to me why you would even propose a rule without having the full vetting of that scientific report that should weigh so heavily on this rulemaking process. And lastly, a point that's been made in front of Panel 1, I think, over and over again, ambiguity. The point of this rulemaking is to ensure some clarity, which is very important for the states that have to implement the Clean Water Act rules. And yet, in our view, at least in the state of Oklahoma, we believe that EPA and the Corps of Engineers have simply taken an already fuzzy line of jurisdiction and simply moved it in a different direction, but it's no less fuzzy than it was before. Certainly defeats the purpose, I think, of this rulemaking process. So we look forward to trying to inform and provide additional constructive recommendations going forward that will hopefully clarify instead of make these decisions more ambiguous. But at the same time, we think it takes more than a couple of 90-day extensions to the comment period in order for the states to be able to engage in a very meaningful and constructive process of informing this rulemaking. Instead, we think what we need is more like a timeout and going back to the drawing board when the train's off the tracks. That's really the only way to get it back on, in our view. So with that, I appreciate the opportunity.
Thank you. Mr. Pfeiffer, your floor is yours.
Mr. Chairman, members of the committee, I'd also like to thank representatives from the agencies who testified in Panel 1 today, because I think they constructively added to the dialogue, but some of the clarifications they made this morning need to be placed in writing, and that's, I think, would serve all of us very well. I'm here on behalf of the National Water Resources Association, which represents urban and rural interests in the reclamation states of the West, as well as the Western Urban Water Coalition, which represents large municipal water and wastewater providers and, in fact, serves over 35 million customers in the western United States. Both organizations certainly fully support the goals of the Clean Water Act. After all, it protects the resource, the water, which our municipal customers depend upon and our irrigators depend upon. So there's no disagreement there. That said, though, our members are the ones who plan for, design, construct, and eventually operate the wastewater and water facilities, the conveyance systems that are so essential in the West, as well as stormwater control facilities. And it's our customers who foot the bill. We believe that the West, especially the arid portions of the West, are sort of the ground zero, if you will, for the impacts of this proposed rule, because we're the ones with the dry arroyos and washes that flow only periodically, with the ephemeral and affluent-dependent stream systems, with the intermittent water bodies and the isolated water bodies and the headwaters. And often they flow only in response to precipitation events or snowmelt. So if the rule is going to have an impact anywhere, it is the West. And so we're watching this very closely. And on first reading, we think this is an expansion of federal jurisdiction. You have this new category of per se jurisdictional waters that didn't exist previously. You have some new concepts of what adjacency means. It used to be just adjacent wetlands. Now it's all adjacent waters. You have this neighboring concept, which encompasses all waters in floodplains and riparian zones. And you have the new significant nexus test that we've heard a lot of testimony about already. But what that allows the agencies to do is aggregate water bodies that individually may be insignificant, and all of a sudden they become significant. So the on-ground impact in terms of the membership of NWRA in Western Urban could be substantial, and it could be very time-consuming and costly because it results in the need to obtain 404 permits where potentially they weren't necessary in the future, even 402 permits, which is point source discharge permits, and certainly 401 certifications from our states, and perhaps most importantly, it can trigger NEPA reviews. And for those of us that have built projects, we know what that means. Let me give you an example. In the last 8 years, I've worked on 2 of the major new Western water projects, either just newly completed or under construction. One is Aurora's Prairie Waters Project. It was $600 million plus. It was a 35-mile, 60-inch steel pipeline, 3 pump stations, a water treatment plant, and some diversions off the Platte River. That project was planned, conceived, designed, constructed, and in operation in 5 years because we were able to avoid pulling the 404 trigger and avoided NEPA review as a consequence. In comparison, Colorado Springs is now constructing an $800 million reuse project, very similar to Prairie Waters Project, also 3 pump stations, a treatment plant, in this case a 50-mile plus pipeline, and a new diversion outlet out of Pueblo Dam. In that case, we couldn't avoid 404, and it took a decade just to get through the planning and permitting process, let alone the 5+ years of construction. And it's tens of millions of dollars in studies and tens of millions of dollars in mitigation. So it does make a difference. And we're concerned about not only those types of projects, but also whether there'll be an impact on the implementation of stormwater control measures. I heard what EPA had to say. I think there's obviously grounds for dialogue and discussion with them. What about activities where you transfer agricultural water out of ditches to municipal entities in times of drought? Because again, the arid West is the focal point for drought, for fires, and for post-fire flooding and necessary remediation. We need to build new infrastructure to respond to all those challenges. It'll only become more difficult if we have to go through NEPA and permitting each step of the way. We have identified in our written testimony some areas where we think a dialogue with EPA and the Corps would be constructive. We fully intend to sit down with them and work through some of these issues, and we look forward to a resolution that achieves a reasonable balance. Thank you.
Thank you. Mr. Williams, welcome.
Thank you, Mr. Chairman. I am here today wearing 2 hats. I am here representing the National Association of Counties, NACO, and also the National Association of Flood and Stormwater Management Agencies, NASMA, where I currently serve as president. We are concerned with the scope of the waters of the U.S. definitional proposal. While the proposed rule is intended to clarify issues, the proposal is significantly broader in scope. It takes federal jurisdiction well beyond the Section 404 permit program and has potential impacts on many of the other Clean Water Act programs. Key terms used in the definition, tributary, adjacent waters, riparian areas, floodplains, and the exemptions listed also raise important questions. It is uncertain how they will be used to implement the Section 404 permit program effectively. While we appreciate that EPA and the Corps are moving forward with a proposed rule rather than a guidance document, our organizations have concerns with the process used to create the proposal and specifically whether impacted state and local groups were adequately consulted throughout the process. Under Executive Order 13132, Federalism, federal agencies are required to work with state and local governments on proposed regulations that have substantial direct compliance costs. Since the agencies have determined that the definition of waters of the U.S. imposes only indirect costs, the agencies state in the proposed rule that the new definition does not trigger federalism considerations. However, the agency's cost-benefit analysis states, quote, programs may subsequently impose direct or indirect costs as a result of implementation, close quote. In addition, we are also concerned with the sequence and timing of the draft science report and how it fits into the proposed process, especially since the document will be used as a scientific basis for the proposed rule. Because of the complexity of the proposed rule and its relationship with the report, the agency should consider not only extending but suspending the current comment period and re-releasing the proposal with the updated economic analysis after the science-based connectivity report is issued. The approach would be welcomed by local governments. Both NACO and NAFSMA believe that the proposed rule would increase the number of publicly maintained stormwater management facilities and roadside ditches that would require Clean Water Act 404 permits, even for routine maintenance. Whether or not a ditch is regulated under Section 404 has significant financial implications for local governments. Not only is the determination often very difficult, the multitude of regulatory requirements under the Clean Water Act can take valuable time and cost substantial dollars, both of which are extremely significant to local agencies. This puts our nation's counties and flood and stormwater management agencies in a precarious position, especially those that are balancing small budgets against public health and safety needs. And while the proposed rule excludes certain types of upland ditches with less than perennial flow, or those ditches that do not contribute flow to waters of the U.S., the key term like uplands and contribute flow are not defined. Therefore, it is unclear how currently exempt ditches will be distinguished from jurisdictional ditches, especially if they are near waters of the U.S. Most ditches are not wholly in uplands, nor do they strictly drain in uplands, since they are designed to convey overflow waters to an outlet. To assist in visualizing some of these concerns, I would like to highlight a portion of my home county, Riverside County, California, and it should be on the screen. The blue line shows the current extent of waters of the United States. The second map shows the likely extent of waters of the U.S. under the proposed rule, a significant increase. And not because of flowing rivers or streams, but because this area is in the arid Southwest, it is facilities like this that will lead to the dramatic expansion. Further, since stormwater management activities are not explicitly exempt under the proposed rule, concerns have been raised that man-made conveyances and facilities for stormwater management could now be classified as waters of the U.S. This would introduce localities to an expanded arena of regulations and unanticipated costs, and that a locality will have to regulate all pollutants that flow into the channel, including surface runoff, rather than at the point of discharge. If stormwater costs significantly increase due to the proposed rule, funds will be diverted from other governmental services, such as education, police, fire, etc. Our members cannot assume additional unnecessary or unintended costs. The bottom line is that because of inadequate definitions and unknown impacts, our associations believe that many more roadside ditches, flood control channels, and stormwater management conveyances and treatment approaches will now be federally regulated. While many of these waters are regulated under current practices, we fear the degree and cost of regulation will increase dramatically if these features are redefined as waters. I'm happy to answer any questions, sir. Thank you.
Mr. Solomon, the floor is yours.
Thank you, Mr. Chairman, Ranking Member Bishop, for holding today's hearing. Farm Bureau has carefully analyzed the proposal that the Environmental Protection Agency and the U.S. Army Corps of Engineers published in the Federal Register on April 21st. We have concluded that it broadly expands federal jurisdiction, threatens local land use and zoning authority, and is an end run around Congress and the Supreme Court. The proposed rule would categorically regulate as navigable waters countless ephemeral drains, ditches, and other features across the countryside, features that are wet only when it rains, and features that may be miles from the nearest truly navigable water. The agencies use scientific-sounding terms when referring to these features, terms such as bed, bank, and ordinary high water mark, to give the impression that the proposed rule would apply only to features that are always wet. However, such terms also define a low spot on the land with subtle changes in elevation, land where rainwater naturally channels as it flows downhill after rainstorms. EPA calls any such feature a tributary. This land is not even wet most of the time, and it is prevalent in farm fields across America. EPA says the rule does not cover ditches. Well, EPA has said a lot of things, and its statement about ditches is simply not true. The proposed rule would categorically regulate all so-called tributaries that ever carry any amount of water that eventually flows to a navigable water. That's a ditch in my world. There is an exclusion that is limited to a very narrowly defined, and one might even say mythical, subset of ditches that are excavated in uplands, i.e. the dry land, and drain only uplands, the dry land, along their entire reach. Over the last few decades, the Corps has added more and more plants and soils that qualify as indicators so it can classify even more areas as wetlands. Now factor in EPA's position that ephemeral drains, also known as low spots, are also waters and not uplands. And you begin to see that one would be hard-pressed to find a ditch that at no point along its entire reach includes waters or wetlands. I've been farming for decades. I've been on thousands of farms all across this country, and I can tell you that ditches are meant to carry water. That is why most ditches will be regulated under this rule. I should also mention that the agencies propose to regulate waters and land that are adjacent to any newly defined water of the U.S., and also add a new category of other waters. This could, and probably will, sweep into federal jurisdiction vast numbers of small, isolated wetlands, ponds, and similar features, many of which are not waters under any common understanding of that word. I'd like to show a few examples of the types of land features the proposed rule would bring under federal jurisdiction. Farm Bureau members from all over the country have been sending us photos of low spots, ditches, and swales on their land. Areas of their land that had the characteristics that would allow EPA and the Corps to assert jurisdiction under this rule. EPA is deliberately misleading the regulated community about the impacts on land use. If more people knew how regulators could use the proposed rule to require permits for common activities on dry land or penalize landowners for not getting them, they would be outraged. It's hard to imagine that only 1,300 acres would be affected, as EPA claims, when we have more than 106 million acres of wetlands that are currently being used for agricultural purposes. That is defined by USDA. In fact, Farm Bureau believes that this proposed rule would be the broadest expansion of regulatory control over land use and private property ever attempted by a federal agency. It takes away land use decisions from state and local governments. It goes against the intent of Congress and the Supreme Court, and it negates your authority as members of Congress to write the law of the land. The bottom line for farmers and ranchers is that the proposed rule will make it much more difficult and potentially impossible to farm near these land features. If farmers must request federal permits to undertake ordinary farming practices on their land, such as pest and weed control and fertilizer applications, and those permits are far from guaranteed, this is, in effect, a federal veto over farmers and ranchers' use of their land to produce our food, fiber, and fuel. I will conclude by reiterating that the Clean Water Act itself and 2 Supreme Court decisions have said that there are limits to federal jurisdiction under the law. Rather than define where there is a significant nexus to navigable waters, the agencies have just hit the easy button and issued blanket determinations that entire categories of water and land are significant. This results in federal control over state, local, and private land use decisions, and it is not what lawmakers had in mind when they wrote the Clean Water Act in 1972. I urge Congress not to allow this unlawful expansion of the Clean Water Act. Thank you for your time, and I'll be glad to answer any questions you may have.
Thank you. Mr. Kelly, welcome.
Thank you, Chairman Gibbs and Ranking Member Bishop. I am a home builder and developer from Wilmington, Delaware, and this year I have the privilege and honor of serving as chairman of the board of the National Association of Home Builders. As builders of communities and neighborhoods, NAHB members have a vested interest in preserving and protecting the environment. Since 1972, the Clean Water Act has played an important role in improving the quality of our water resources and the quality of our lives. Despite these successes, there continues to be frustration and uncertainty over the scope of the Act and the appropriate role of the federal government in protecting the nation's waters. There still is no easy or predictable way to determine if certain types of waters are subject to mandates of the Clean Water Act. Therefore, to better facilitate compliance and improve aquatic environment, the U.S. Corps and the EPA recently issued a proposed rule intended to alleviate uncertainty and clarify what areas are subject to federal regulation. Unfortunately, and as we've heard today, the proposal falls well short of providing the needed predictability and certainty. It also fails to follow the intent of Congress and Supreme Court precedent. Instead of limiting jurisdiction, the proposal unnecessarily increases federal power over private property. Moreover, the proposal rule will provide little, if any, additional protection because most of the newly jurisdictional areas are already regulated at the state or local level. Although the agencies claim the rule does not expand jurisdiction, this is simply not the case. The rule would establish a broader definition of tributaries and include areas not currently federally regulated, such as adjacent non-wetlands, as well as low spots within riparian areas and floodplains. Further, due to ambiguous definitions, the agency would retain extensive authority to interpret the scope of the Act as they see fit. As a businessman, I need to know the rules of the road. I can't play a guessing game of, is it federally jurisdictional? But that's precisely what this proposal would force me to do. Additionally, despite the fact that the Supreme Court has twice affirmed that the Clean Water Act places limits on federal authority, the proposed rule would assert jurisdiction over many features that are remote, carry only minor volumes of water, or have only theoretical impacts on waters of the United States. In essence, the proposal ignores Supreme Court rulings. Ultimately, the rule would put more areas under federal government jurisdiction, which will lead to more litigation and project delay, more landowners needing permits, and higher costs of permitting, avoidance, and mitigation. And these expenses are not insignificant. The cost of obtaining a wetlands permit can range from tens of thousands of dollars to hundreds of thousands of dollars, and that does not include the cost of mitigation or project delay, which can be very substantial. As you can understand, the proposed rule will have real impacts on the construction industry and ultimately the cost of developing homes and rental apartments. To make matters worse, the agencies have not considered the totality of the rule's impact or its unintended consequences. For instance, if the rule is finalized in its current form, builders may, and I underscore may have to obtain permits to perform maintenance on certain standard stormwater management controls because they will now be federally jurisdictional. Yet the agencies have all but ignored these realities in their analysis. Equally problematic, the agencies have not completed, as has been said today, the report to serve as the scientific basis for the rule. Although the EPA administrator recently affirmed the importance of science in guiding the agency's decision-making process, the agencies have pushed ahead with the rule without the necessary scientific data to support their conclusions. Defining which waters fall under federal authority is not an easy task, but the federal government cannot take the easy way out by illegally asserting jurisdiction over everything. If agencies are interested in developing a meaningful, balanced, and supportable rule, they must take a more methodical approach, one that is based in fact and common sense and is true to the Clean Water Act's intent and the Supreme Court precedent. Thank you, Mr. Chairman.
Thank you. Mr. Henry, floor is yours. Welcome.
Thank you, Mr. Chairman, for your time. My name is Eric Henry. I'm from Burlington, North Carolina, where I've lived for 50 years and had a business there for over 30 years. The T-shirt and jeans I wear today are made and grown in North Carolina from a supply chain I helped develop called Cotton of the Carolinas. I understand the value and importance of clean water to both my business and my community, and I hope you will recognize that protecting the resources is invaluable to a business like mine. I would also like to add, I think you get brownie points today by saying that you're connected to a farm. So my wife and I moved to a farm 3 years ago, so we understand the value of clean water. Burlington, where I live, used to be a very large textile town, home to many companies like Burlington Industry, which was founded in 1923, one of the largest textile companies in our country. I remember growing up, there was a small stream across from where I lived called Willowbrook Creek, where I lived for over 26 years before I finally moved out. My parents kicked me out. And I remember going across that stream and seeing blue, red, green, dead fish, dead crawfish. Times it would smell. And this was pollution that was coming from the textile mills in our community. That got polluted to the point where it was like a toilet bowl that our community could drop their commercial and residential waste into. Today, the Hall River, which is a critical part of a main tributary that comes to our county, old mill communities like Saxpaw and Glencoe communities have been dying out, and now are becoming sought-out places to live, work, and play, much is due to EPA's clean water regulations. As a small business owner who started a business over 30 years ago while attending North Carolina State University, I've witnessed firsthand the positive changes that come from bringing clean water back to our community. My T-shirt and my jeans that I wear today reflect my business philosophy of a triple bottom line of people, planet, profit. This is a particular shirt of Cotton, Carolina. We go dirt to shirt, covering every step of the production process from the farm to the factory, while supporting 500 North Carolina jobs in a completely transparent supply chain. You see the product I'm wearing and get the benefit of wearing the product today instead of the high-priced suits that most of you have to wear today. As a business owner with the daily focus of meeting payroll and growing sales, I appreciate the value that my government partner brings to the table, the long-term value of clean water and clean air. I believe we have an obligation not just to protect the water for our communities we live in today, but ensure that for future generations that we have access to that clean water. If protecting future generations not only true matters to you, this is how we can show it. This is not a unique perspective on a business owner. As part of the American Sustainable Business Council and the polling we've done, 92% of small business owners support the idea where regulations to protect air and water from pollution and toxic chemicals. And I'd like to point out that 47% of that sample group were self-identified as Republicans. Clear nation water protections are critical to making the waterways safe for families to swim, fish from, and depend on for drinking water supply. They will ensure that playing fields stay level and that businesses like mine will be playing by the same rules as everyone else that are fair and it's simple. Some people today only see the higher cost of cleaner water and the impact to their bottom line. They miss the long-term view. What happens when the water is polluted? You now have to look at the impact of the Elk River spill in West Virginia and the concerns that spill have it spread downriver into Kentucky. You only need to look at the recent spill in my state, downriver, where Duke Power and the coal ash spill, tens of thousands of coal ash spill were discharged into the downriver. The companies responsible for those spills don't benefit from them. The Dan River spill is costing Duke Energy millions of dollars, and companies responsible for the Elk River spill, Freeman Industries, filed for bankruptcies. Companies like that, which rely on a consistent source of clean water, certainly don't benefit. The people in these communities, the ones who can shower, bathe, or wash their clothes, they don't benefit. Our economy doesn't benefit. The Elk River spill cost West Virginia economy $19 million a day. And according to research at Marshall University, by contrast, clean water rules you're discussing today would have between $388 and $514 million in annual benefit compared to the $162 to $270 million in cost. There's a strong economic cost for regulations, not against them. We need to be the world leader in setting the bar higher, not just for cheaper and more polluted future. That's why I'm asking you to support EPA's move to protect our clean waters, the people we respect, and the companies that rely on for jobs, economic growth. Well, thank you, and thank you for your time.
Thank you. Thank you all for coming in. I guess my first question to anybody who wants to answer, I'm really concerned. I believe when the Clean Water Act was passed in 1972, it was set up to be a partnership between the federal government and the state governments. And I think we've come a long ways, especially in point source pollution and even non-point now, to protect and enhance our environment and our water quality. And I'm concerned that this proposed rule has potential to erode that state-federal partnership because, first of all, I think we heard today that the state EPAs haven't been involved or consulted in the proposed or the drafting of the rule, and that doesn't sound like too much of a partnership to me. So does anybody want to comment about the state's rights to this, about how you think the Clean Water Act has been functioning and how it can function even better, if the state's involvement is a partnership? Because I would argue, Mr. Pfeiffer, when you talk about the differences out west, a one-size-fits-all policy out of Washington, D.C., to me is a problem. And we have an umbrella here, but what happens if the states don't have that, are able to have that input, to have that enforcement when we have issues that come up and step in? What's the long-term implications if this proposed rule goes through as it's drafted right now to that partnership?
Well, if I could start, I think one of the implications is that we won't have the degree of flexibility that's necessary to implement it on a more regional basis, if you will, based on different hydrologic and geologic and climatic conditions that we need to be aware of. In addition, we have different water rights systems. We have a prior appropriation system in the West as compared to the riparian system in other portions of the country. And that influences, I guess, the way we address our waters and deal with issues surrounding both discharge of pollutants and what is jurisdictional. And that partnership does seem to be eroding, and we need to find a better balance such that everything doesn't need to be federalized in order to be, we have to recognize everything doesn't need to be federalized in order to be protected, that state and local governments, both of which implement the Clean Water Act and the Safe Drinking Water Act, can do a very good job based on the site-specific conditions that they are faced with and the cost constraints they are faced with, and we have to trust them to do that job.
Mr. Strong?
Yes, no, I would just absolutely agree with what Mr. Pfeiffer just said and add that, in fact, as an example, a lot of the success stories in cleaning up water quality in the United States, some of which are featured on EPA's website, include projects that were done in the state of Oklahoma on a voluntary basis with our state agencies working in partnership with our landowners and producers to accomplish those great successes in cleaning up water quality in the state of Oklahoma without regulatory, Clean Water Act regulatory burdens being placed on.
I think you touch on a very important point that I want to make, so anybody who's tuning into this can understand this, that I said this to Secretary Darcy in a budget hearing about a month ago, that this proposed rule they're putting out, I think to the average citizen out there that has in their mind what navigable means, what I think navigable means too, but they're implying then that waters that aren't navigable aren't being regulated. And we all know this isn't the 1960s anymore. And obviously there's been instances, I know Mr. Henry cited a couple, where we've had our challenges, and then there has to be enforcement that has to happen. But the states are regulating, the local governments for that matter, and so all waters are being regulated. And my concern is this rule erodes that partnership and maybe doesn't enhance or protect the environment or water quality, but actually could go backwards. So I'm very, very concerned about that. Mr. Stallman, on the agricultural side, we had Secretary of Agriculture Volstead, the Ag Committee, about a month ago, and he said normal farming practices are exempt. But then he had the list of the 56 that they specifically say they're exempt. Now, I think he was implying, I didn't have a chance to follow up, that agriculture under those 56, if they're working with NRCS, are exempt for 404 permits. But I'm not so sure. I'd like to see your viewpoint on this. Is all normal farming practices, that's the Farm Bureau sees it, exempt from 401 and other permitting under the Clean Water Act?
I appreciate the opportunity to comment on that, including probably some of Mr. Perciasepsi's assertions about the exemptions for farming. The interpretive rule, you have to look behind the curtain and understand what the law is and what the rule actually says. First, those normal farming and ranching exemptions only apply to Section 404, not Section 402, which is the NPDES permitting, which is now required for point sources, which is a nozzle that applies an agricultural chemical. That's number one. Number two, it only applies to farming and ranching that has been ongoing since 1977. That was the assertion of the government in a court case in 1987, U.S. versus Cumberland Farms of Connecticut, and that has been the position of the EPA and the Army Corps of Engineers, that the normal farming exemption does not apply for those who have not been continuously in operation since that time. That would be a lot of older farmers. I started in 1974. Yeah. The other is that by requiring compliance with NRCS standards, now remember, these have been voluntary incentive-based programs in the past, you are actually morphing them into a regulatory program and using those standards as part of a permission process to conduct normal farming and ranching activities. Two other points. I think I don't remember if it was Secretary Darcy or Mr. Perciasepi indicated that those 56 practices were the ones that would help improve water quality. Well, let me tell you what was left out. The practices that were left out that do contribute to farming, to water quality in terms of farming. Conservation crop rotation was left out. Contour farming, cover crops, nutrient management, terracing, and the massive use of no-till and minimum till in agriculture today, 96.5 million acres for no-till cropland, conservation tillage excluding no-till, 76 million acres. That was excluded from these exemptions, and I think most farmers today would concur that those are normal farming and ranching practices. Yeah. Secretary Darcy also seemed to indicate you would not need a permit for spraying chemicals on farmland. Well, that's true as long as none of them are identified as waters of the U.S., and that does not mean spraying it in the water. That means the ditch that would be identified as a water of the U.S. that a molecule of chemical could get on. You still need to have a permit.
We'll get back to the ditches, but my time's out right now. I'm going to turn it over to Mr. Bishop for any questions you may have.
Thank you very much, Mr. Chairman. I thank the panel for their testimony. I also thank you for your patience. It's been a long morning. Mr. Henry, let me first thank you for pointing out the connection between an environment that is maintained at a reasonable, if not the highest possible level, and economic growth and economic stability. I represent the easternmost 75 or 80 miles of Long Island. The easternmost part of those 75 or 80 miles has among the highest property values in the country. And Mr. Kelly, I will tell you that it has some of the more successful and prosperous builders in the country. And those property values are what they are, and those builders are as successful as they are because of our efforts to protect and preserve the environment. And if the Long Island Sound were not a swimmable or fishable water, or Peconic Bay, or Big Fresh Pond, or Little Fort Pond, we would not have the property values we have. So I think we all have to agree that we have made great strides with respect to regulating our waters, and that in making those strides, they have been supportive of economic development as opposed to antithetical to economic development. Having said that, I also think that we ought to the greatest extent possible, try to have a fact-based conversation. And there's, I think, several of your testimony, you all each said, many of you said, that this regulation is in violation of congressional intent and in violation of, or in antithetical to Supreme Court rulings. That's simply not correct. In 1972, when the Clean Water Act was debated, it was debated whether or not navigable waters of the United States should be defined as navigable in fact. And that interpretation was rejected by our predecessors. It was also rejected by the Supreme Court in 1975. In Justice Scalia's opinion in Rapanos, he said, and this is in his opinion, the court has I'm now quoting, twice stated that the meaning of navigable waters in the Act is broader than the traditional understanding of the term and includes something more than traditionally navigable waters. This is Justice Scalia. Justice Kennedy came up with the significant nexus test and then directed, along with Justice Roberts, the two agencies involved to try to define waters that would meet those tests. And as Mr. Kelly said quite correctly, this ain't easy. This is really, really hard. And they're trying to do that, and we now have a process in which stakeholders can influence the outcome of that. But here's something that I would hope you can guide me or help me with. If this rulemaking fails, or if this rulemaking is withdrawn, or if we pass the Energy and Water Appropriations Bill and language that is currently in that bill survives into law, that language says that, that federal funds may not be used to promulgate this rule, we are left with the 2008 guidance. Now, I'm going to read from something that the American Farm Bureau and the National Association of Home Builders submitted in 2008. And it said, and I'm quoting, "The guidance is causing confusion and added delays in an already burdened and strained permit decision-making process, which ultimately will result and is resulting in increased delays and costs to the public at large." So my question is, A, does that represent the current position of the authors of that letter? And B, is it your position that the 2008 guidance is preferable with its flaws and imperfections as outlined by your two organizations? Is it preferable to the regulation that is currently being proposed?
The first answer to that, Mr. Bishop, is that we did ask for rulemaking because a guidance is not a rulemaking. A guidance does not allow for public notice and comment.
And you asked, and they're delivering. They don't
delivering,
like the rulemaking, but they are in fact proposing a rulemaking.
They're
correct?
proposing a rule.
Yeah.
Now, getting back to the Supreme Court decisions, the one thing that has not been mentioned here this morning is that Justice Kennedy also wrote that remote and insubstantial waters that eventually may flow into navigable waters would not qualify under his definition of significant nexus. These proposed rules, definitions, and descriptions go far beyond what he says would not qualify. So I'm not sure. I think there's a difference of opinion here about whether this proposal is within the boundaries, as you call it, of the Supreme Court cases.
Okay. But if I may, does the statement that I just read, does that represent the current position of the home builders? So my question, to be specific, is the 2008 position of the home builders also the 2014 position of the home builders? I'm sorry.
I'm the Farm Bureau. Yeah.
Farm Bureau.
Okay.
I do know the difference, by the way.
We do want a rule that restricts the scope of authority under EPA based on the Supreme Court rulings that both have said that their scope is not unlimited.
Okay. I want to let Mr. Kelly answer, and I don't want to be argumentative, but I want to come back to a point. Mr. Kelly.
The 2008 rule is clearly preferable to the proposed rule. And given the choice, we would live with the 2008 rule.
With all of its imperfections.
With all its imperfections. And we have repeatedly pointed those out, and we have repeatedly asked for a new rule. But this rule is simply unacceptable to us. Going back to the question you touched on a little while ago about the permitting process, the last time we had figures that when we studied it, a nationwide permit took about 788 days to acquire and cost north of $280,000 without the mitigation that might have gone along with it. A streamlined permit, based on, again, the most recent information we have, and this goes back more than a decade, cost $28,000 and took 313 days. this just creates massive costs and uncertainty for home builders. I would also suggest that the current proposed rule may have the effect of creating a pall on land development in this country. And one of the greatest challenges facing the home building industry now is the availability of buildable, developable land. Because, as you can understand, nothing was taken through the pipeline from 2007 to recently. Nothing was brought through, so our members continue to tell us that they cannot find platted approved land to develop on. With this rule in place, there's a segment of our industry that specializes in platting and planning land for merchant builders to acquire. They don't know what the rules of the game are at this point in time, and why would they spend hundreds of thousands of dollars on engineering when they have no idea whether their piece of land will be subject to these very vague and ambiguous rules?
My time has expired. Thank you very much, Mr. President.
They're going to be calling votes shortly, and I'll announce when that happens. But Mr. Mullen, they haven't called you yet. Go ahead.
I was going to say that was not that I understand the bells around here, nor does anybody else, but I was getting confused there. You had the TV on. That's how I figured out when the votes are happening too. Once again, I appreciate the panel for being here, and Mr. Kelly. Ironically enough, I have a couple of property companies. We're in the process right now of trying to get about 20 acres platted, and it is absolutely absurd what we're having to go through. And the last time I had to go through, and the last time I actually purchased non-platted land, which is very scary, was 2007, I believe. And back then it was tough. Now, I don't even know if it's a chance to take. And so I do understand with what you're saying. I want to spend a little time with Mr. Strong. I think that's the first time I've ever called you that. It's always been J.D. But hey, official titles, right? I want to spend a little bit more time with you on understanding a couple of things. One, I understand that you have been told, that your agency has been told that the rulemaking is going to be handled on a case-by-case situation. Is that accurate in saying that?
Yes, that is accurate. When we, of course, asked some of our regional district offices what the impact of this new rule would be on jurisdiction within our state, we were told essentially that it will continue to be, those types of decisions will continue to be made on a case-by-case basis, which sort of begs the question whether or not we're clarifying anything for anybody if every decision has to be made on a case-by-case basis.
So if you're already being told that, then the uncertainty that runs just in the state, not to mention by the time it trickles down to the farmers and to the home builders and to the other industries that depend on this. But when you're getting asked the questions, are you able to even make a decision now?
No, we're not. We absolutely are not. And you sure can't tell, I think, from reading the rule. Certainly the additional questions and answers from this hearing and follow-up calls that we're having now with the agencies are helping to clarify things. But I think, as Mr. Pfeiffer said, what's important is what's in writing. And so even though we may get some clarification outside the language of the rule through these types of forums, we need clarification in writing to give folks the finality that they need to be able to plan their businesses, their developments, and as a state to be able to implement these important programs to protect water quality in our states.
So once it's clarified, how much time are you going to need to be able to get your agency spun up to be able to even comply with the new rule that may or may not exist until you get a case-by-case clarification on it?
Well, I think if at the end of the day we got enough clarification in the rule that would support the statements made in the earlier panel that this really isn't any expansion of jurisdiction, then we would expect that it would have really sort of no additional impact on the burden on the states to implement the law. So really, it all sort of depends on what that clarification looks like. If it does, in fact, change the scope of jurisdiction in any way, then it would take us more than 90 days, I can guarantee you that, to figure out what the impact would be on the states and our programs to implement these Clean Water Act programs, as well as on our regulated communities.
Have you guys already identified some I guess what's the word I'm looking for here? Have you guys identified areas to where the state and the federal agencies are conflicting with each other?
Well, I think certainly you could easily read the rule as it stands right now and identify areas where what we thought before was totally subject to the state's jurisdiction could now be under the federal jurisdiction, which essentially removes the flexibility that was discussed earlier that's necessary for us to implement these programs in our states, in our various states, with our very unique hydrology that's vastly different from state to state.
I appreciate your time being here, J.D. It was always a pleasure to visit with you. Mr. Stallman, I want to go back to you real quick. With the Farm Bureau, the point I made earlier about existing farms, existing permits, have you guys had any clarification on this at all, such as what they were referring to?
No, not as was referred to by Mr. Perciasepi and Secretary Darcy. What we do know is it has been the position of the Corps and the EPA, based on a court case in 1987,
right.
U.S. versus Cumberland Farms of Connecticut, that unless from 1977 on you had maintained a continuous farming operation for which you had an exemption there under the
right.
law that was passed by Congress, unless you maintain that continuously, you didn't qualify. That means there are no young farmers and ranchers that will be exempt.
So, and if you could, just a couple more seconds here. So the heartbeat of this country, being the farming community, in my opinion, is threatened here by seeing permits that are required to do some of the farming that we have to be less available or even non-existing. Are you hearing that from your members, or is that kind of assessment you guys are taking on your own?
More and more, as the information of the rule has gone out to our members and they understand what the potential impact it could have on their farming operations, we are hearing that it will just not work. This law was never designed to regulate on a permitting basis agriculture.
Yes.
Our property is measured in acres, not in square feet.
Yes.
And the timelines involved in agriculture, the integration of what we do with whatever Mother Nature gives us, we don't have time to get the permits as the timelines are indicated it takes to get one, much less the cost of getting one. I'll be honest with you, if my farm is determined to need a permit to conduct my normal farming operations that have been conducted for over 100 years there's not enough profit margin for the cost of
sure.
permits for me to make an economic decision to seek a permit and continue farming.
Thank you, panel, for being here. Thank you, Chairman.
We're still good in votes. It's got 8 minutes. 410 people haven't voted yet, so I want to ask another question. There's a lot of concern, really concerned to me, about this ditch thing and the tributaries. We had the first panel, and there's unclear. And when you read through the rule and the preamp and some of the things in the rule, I think you can conclude that, at least I do, that ditches can be tributaries, and tributaries are not subject to significant nexus test. Tributary ditches, then, are categorically included, and significant nexus does not apply under the rule. Does anybody want to comment on that? Do you agree? I mean, the EPA said today that tributaries are included on the rule, and that ditches can be included and then don't have to meet a significant nexus test. Am I interpreting that right? Bob, do you want to?
We agree. These are categorical definitions, and regardless of the assurances and intent expressed by government officials, the only thing that will make a difference in court and litigation is what do the words of the rule say. We have seen EPA and the Corps throughout 30-plus years of litigation seek the very strictest definition that gives them the broadest scope of authority. And so when you say bed, bank, and ordinary high water mark, I can show you several miles of ditches on my farm that have those characteristics. And, then they become a regulated water, and they are not today.
Yeah, so when I heard the previous panel, kind of answered those questions we asked about ditches. They kind of inferred that most ditches would not be included, and I think they even inferred that local governments' road ditches would not be a problem, would not take a permit if they're going to do any cleaning of the ditches, because I specifically asked that question. So, you're shaking your head, Mr. Williams, or Mr. Pfeiffer?
Well, just real quickly, I heard from the previous panel that roadside ditches generally drain uplands and don't go anywhere. In my county, when we collect the water, we have to take it to an outlet, and that is generally a tributary or some adequate outlet. That, by definition, in their definition, is the roadside
so
ditch.
a follow-up question then, if it's ruled in, or if they rule it, or it happens to be litigation, then you have to get a 404 permit to clean your roadside ditches. Then you, as a local government entity, I would think would be liable for not keeping the integrity of the ditch, but maybe you couldn't get the permit fast enough. Can you see a scenario like that occurring?
Very much so. It's time and money. Both of those will be severely impacted. I agree with you.
I would just add that most ditches, and certainly in Colorado and most areas in the West, or at least the arid areas, take water off traditional navigable waters. I mean, by virtue of their water rights decrees, and then oftentimes they have an obligation even to return the water that they don't consumptively beneficially use to a water of the United States. And so therefore they are jurisdictional. And most of them have historically been jurisdictional. So, yeah, you can't generalize and say most ditches are excluded.
Well, me as an elected representative, I interpret this as either their intent is a good intent, or they've got a hidden agenda and are not being truthful. I just don't know. I mean, I'm really concerned about this, because you guys made some good comments and good statements here, and some of their statements on the previous panel was, I don't think so, I'm not sure. Talk about ambiguity, raising the vagueness and the ambiguity of the whole issue is really concerning, and I think it does open it up to litigation at the very least. Would everybody concur to that we've really got an issue here that in the future, if this goes through this way?
Mr. Chairman, can I make a comment, please?
Yes.
We're talking about ditches, we're talking about cost. We're talking about the lifeblood of society. It's the water that goes through that. What I look for the federal government for is that long-term vision of the protection of that water. And I think if you step away and look at the global implications of water and society, we got some serious problems ahead of us. So we really have to look, step back. I mean, this is a very serious problem we're dealing with. I think we're getting into the trenches, and we're missing the big picture. I mean, destroying our water quality affects the quality of our life. Look what's happening to China right now.
China, there's no regulations over there. That's part of the issues. But I would think that, go ahead, Mr. Stallman, you can comment.
Let me respond to that. Yeah, that's the big picture stuff. But let me talk about how it works on the farm. Prescribed grazing is one of the so-called exempt practices for those few farmers that will qualify for it. So the implication is, if you do not qualify for it, then prescribed grazing is not an exempt normal farming and ranching activity, and therefore, if you are doing prescribed grazing in a ditch, and you have to understand, my country's kind of flat. We have a lot of ditches where we let cows graze to keep them cleaned out, where they actually will carry water. If that requires me to fence off those ditches to keep them from grazing, or to get a permit to allow those cows to graze there, once again, I'll shut it down, because the cost, the economics will not work. So that's where it gets down to the farm.
Yeah. And Mr. Henry, I don't think anybody on this panel or anybody on this diocese doesn't want to do everything we can to make sure that our water quality is improved and we enhance it and protect it. But we can also regulate ourselves to death and actually go backwards. And the one example I've talked about previous hearings from the EPA is my personal example as being a former hog farmer. The years the hog market went south, what we tried to do was stay in business, pay the employees, pay the bills. In the years we could make some money, then we looked at doing things on the farm to improve grass waterways and do things. But if we put so much burdensome regulation on people like farmers like Mr. Stallman, the environment's going to suffer, and so we got to be reasonable about this, and we should never forget that the Clean Water Act was set up to be a partnership between the states and the feds, and this concern I have with this rule moving forward is that it's eroding that partnership, and we will have degradation of our water quality in the United States and also hurt our economy and jobs. So I need to conclude. We have to go vote. I don't think there's any reason to come back. I think we've pretty much got the message, and everybody had their point. And I really do want to thank you for coming in and being here for several hours. So this concludes the hearing. Thank you very much.
Thank you, Bob.
Yep.